family history, I'm very much interested in this topic, and I think it's very important. It's very important that this is discussed. That this is discussed in an historical and important institution like ours. And it's important that European people keep thinking of this. This is, one of the things on which we found really the foundation of our society cannot avoid thinking of these processes. And I'm sure that this is an opportunity for you to develop new idea, to share experience. And every time there is this meeting of ideas, of different experiences, always something good happens. So this is what I wish you, to come up with something important.
È iniziata anche la... Prof, mi sente?
Yes.
Damiano.
Ok.
È iniziato il broadcast su YouTube e l'ho mandato il link.
He wants to say that it's going on YouTube in the same time, so you can follow this, and whoever wants to follow on the YouTube, and probably we will be able to well, to keep it on YouTube for those who were not able to follow at this time. I'm sorry, Professor. I'm sorry, Rector, for this. I think that Damiano maybe didn't realize that you were, you were just talking and delivered this inauguration.
No, it's not a problem at all. Anyway, I was basically done. I just conclude saying that I'm really sorry that I cannot attend the day because I had other commitments, but this is the good news, the fact that this will be available afterwards, such that even people like me that are interested, even if cannot participate to the discussion, will be able to catch up later on. And again, congratulations for this. I wish you all the best for this work, and I'm looking forward to knowing what are the ideas that will be developed during this meeting. Thank you very much, and all the best.
Thank you very much, our Vice Rector, for those kind words. Thank you very much. We are really delighted that you were able to make and introduce this event. So thank you for coming, for those warm words, and I hope that we will have very fruitful day today. So thank you again. Right, now thank you very much to all. I just would like to say that how did we organize this event, and what sort of planning we have today. So we looked at vulnerability from the position and from the definition which we have in the SIA system. Then we might consider that the UN Convention on Disability, or the general definition of disability, might have some differences in this, and this would be a very interesting topic to explore. We also considered this topic from multidisciplinary perspective. So we have here some historians, we have political scientists, lawyers, who approach this topic from different perspectives. So there is absolutely nothing wrong, and that provides more details and more ideas to protection of vulnerable group. I should say that first of all, so let's introduce our first speaker. I'm really delighted that we have some representatives at the national Red Cross at national level, and this was also a very important element of our Jean Monnet activity, to incorporate in our work NGOs, local NGOs, national NGOs, and to exactly discuss things in practice. I also saw Dr. Federica Baltasari will present vulnerable groups in the migration routes, separated families and missing persons. And I think that this is a very, very interesting contribution, because finally we have not seen, we divided the definition in several ways, but we have not considered this. So you were the only one talking about separate family and missing persons, and this is a very important topic. So thank you very much for being here, for being enthusiastic about the event and accepting our invitation. So Dr. Baltasari, the floor is yours. Do you know how to share the screen if you have PowerPoint?
No, I will speak.
You don't have any PowerPoint. Okay.
Yeah, thank you.
No problem whatsoever. Okay, so the floor is yours.
Thank you. Good morning, everybody. I'm Federica Bellassai. I know that my surname sometimes is difficult, but it's Bellassai from the Migration Department of the Italian Red Cross. Firstly, let me thank Mrs. Gromek for this invitation, because for us it's a pleasure and an honor to be here today with you to discuss about these important topics for us, because the support to the family members of those missing, for the Italian Red Cross and for the movement of the Red Cross and Red Crescents is crucial and is central for us, for our intervene, especially in the framework of migration. That is one of the major challenge that the Italian Red Cross is facing in these years. In the context of migration, the Italian Red Cross supports people during the journey thanks to the capillarity of the International Red Cross and Red Crescent movement. Especially in Italy, the assistance to the migrants is provided during the presence in the country, and specifically, the Italian Red Cross assists people upon their arrival by sea, in the border, and in the transit areas, as well as in the reception facilities. A mention should be made with reference to people on the move, assisted by the Italian Red Cross through the humanitarian service point in different locations of Italy. When we speak about assistance to migrants, we talk about a comprehensive approach, comprehensive protection approach customized to the specific vulnerabilities and need, regardless the legal status of the people, of the migrants, that for us is really important to underline. With regard to the mentioned protection approach, we have to take into consideration the vision of the International Red Cross and the Red Crescent movement as a whole. Alleviating the suffering of the vulnerable is indeed part of the humanitarian mandate of the Italian Red Cross, in compliance with some international strategies. One of these is in particular the International Federation of the Red Cross Global Strategy on Migration 2018-2022, reducing vulnerability, enhancing resilience. It includes a definition of migrants as a person who leave or flee their habitual residence to go to new places, usually abroad, to seek opportunities, safer and better prospects. This includes migrant workers, stateless migrants, migrants deemed irregular by public authorities, as well as asylum seeker and refugee. In this framework, we move to the concept that we adopt in terms of vulnerability. Vulnerabilities as expressed in the IFRC migration policies and as reflected in 10 points and 10 principal mentions is a concept very, very particular and that influence our activities with people, especially with migrants. In this humanitarian approach, all the action are undertaken based on migrants' needs and vulnerabilities, regardless the legal status. Among these principles, of course, it's relevant for us to mention the special focus on the needs and vulnerability of migrants, as well as the support to their rights, for example, the humanitarian advocacy, and the action aimed at alleviating the pressures sometimes in the country of origin and the communities of origin. Vulnerability in this context can be defined as the diminished capacity of an individual or a group to anticipate, to cope with, resist, and recover from the impact of a natural or man-made hazard. The concept is really dynamic and also relative. Vulnerability sometimes is often is sometimes associated with poverty, but it can also arise when people are isolated, insecure, defenseless in the face of risk, shock, or stress. In line of this vision, the Italian Red Cross considers the separated families and the families of those missing as people in a particular vulnerable condition. Assistance and protection to those vulnerable is ensured thanks to service, an international worldwide service that is called Restoring Family Links. The RFL service works worldwide to prevent separation, help families to restore and maintain the contact with their loved one, as well as support family reunification, clarify the fate and the whereabouts of the missing. In this framework, for us, it's really relevant to also mention the Geneva Convention, specifically the first protocol, the first additional protocol to the Geneva Convention on the protection of victims of international armed conflict. Because in that protocol is established a general principle: all parties involved shall be prompted mainly by the right of families to know the fate of their relatives. This principle guides the action of the Italian Red Cross as part of the international movement. Also, the concept of missing person is really important for our mandate and all the action we do in our territory and in our services, because a missing person is the person whose whereabouts are unknown to the relatives or to the families, or sometimes based on reliable information has been reported missing in accordance with the national legislation in connection with an international or non-international armed conflict, a situation sometimes of an internal violence, natural catastrophes, but especially including, and this is for us important to underline, any other situation that may require the intervention of a competent state authority. If the disappearance affects many dimensions of the society, especially in the context of migration, this is really important because migrants are one of the most affected by separation from their family members. In 2003, a conference of experts convened by the ICRC Red Cross, the International Committee of the Red Cross, identified several specific needs on the basis of the experiences of families of missing persons. Those needs continue to be actual within the experience of the Italian Red Cross in the framework of migration and according to our experience. Among those needs, we can mention a lot of different needs we collected in these years. For example, the need of the family to know, to ensure commemorative rituals, to receive legal, administrative, economic, and also psychosocial support. When it comes to mention specific vulnerables potentially in need of assistance, we have to refer, for example, to migrants arriving by sea. I don't know if probably you know that the Italian Red Cross this year is also present during on the quarantine boat due to the COVID-19 pandemic, or for example, the unaccompanied minor. Assistance to them is provided according to the law and according to the different need they have and they present, as well as the potential victim of trafficking, because with them we meet different challenges in our action. They require attention to protect them from the risk to be traumatized, but sometimes also re-trafficked. Go to the challenges. The Italian Red Cross is facing several challenges while assisting separated families and families of people missing in the Mediterranean Sea in particular. First of all, assuring protection means also protection of personal data of people in need, especially for the principle do not harm, inspiring all the action we do to protect people, especially in consideration of the migration phenomenon, that itself means to assist worldwide families through the Family Links network by sharing personal data of both migrants, inquirers, and their missing loved one, that we don't know about their whereabouts. Secondly, also families need assistance to clarify the whereabouts of their family members, and sometimes is really important to facilitate the dialogue with all the competent authorities, especially in the framework of the identification procedure for migrants victims of shipwreck that occur in the Mediterranean Sea. The fragmentation of the legal framework is a challenge, and especially the different practices adopted in the field to recover and manage the bodies of migrants that for us represent an additional element that should be taken into consideration. We can say that together with the fact that in most of the cases families separated are abroad, all these elements in a certain way increase the state of vulnerability of the people. Also the concept that sometimes influence the family member that are waiting for answers in the country of origin. We can talk about also on the concept of ambiguous loss and all the related aspects that are linked with the ambiguous loss. For example, the psychosocial support and also the accompaniment of the family members during all the procedure that involve clarify the whereabouts of their family. Particular mention also to the victim of shipwrecks, especially in the Mediterranean Sea, because our country is really affected by these tragedies and these critical events. The mention of the migrant surviving shipwrecks is fundamental in the sense of considering their vulnerabilities and their vulnerabilities, as well as the importance to involve them in the process aimed to clarify the fate of the missing person of that particular incident, for example. On one end, the Italian Red Cross is working to assist separated family by collecting data as part of the effort aimed at clarify the fate and the whereabouts of the missing. But in the other end, it should always take into strong consideration the specific vulnerabilities also of the witnesses of this tragic event occurred in the sea. In particular, we refer to the risk of traumatization to live again that memories, as well as the need of a target psychosocial support. To conclude, all the diversity of need due to the disappearance and its related challenges require an holistic approach, and this is really crucial for us. It should include action taken to all the levels and by several stakeholders. For example, the accompaniment of the family of missing during the identification procedure, the facilitation of the contact with the competent authority, and also the role of the forensic, especially when it comes to procedure aimed at comparing the DNA of the families and the bodies. The Italian Red Cross is working on this sensitive file in order to provide response to the family of the migrants to whom they have been separated due to the several reasons, as well as to provide and to give dignity to the body of the migrants that died trying to cross the Mediterranean Sea. This is our experience, and I hope it was interesting for us to understand a little bit our framework and our scenarios. And thank you very much again.
Thank you very much. Did I mispronounce your name, Balasai, at the beginning? Maybe the accent was wrong. So
don't worry.
Right. So thank you ever so much. This was extremely insightful and very interesting talk. I would have several questions and maybe several points that we might discuss or develop further on. For instance, exactly this vulnerability in the rescue operations, which at one point was even my talk somewhere. Also, well, exactly what sort of support is missing? So this would be also my question. But first, I will open the floor for other questions. So any questions? Anybody has a question? So please, because I'm sure that well, we could collect different talks and do questions later on, but I know that people are busy, so they want to do different things. So any questions? Anybody wants to ask the question? It's too early. Can you hear me? Yeah?
Yes. Ciao. Hi.
Oh, hello, hello, hello. So any questions?
Nothing.
You have one?
No.
No, so I have those questions. So what do you think for these vulnerable groups? What could we do more? I know that my question is maybe too general. So maybe because you were mentioning in rescue operations. So what sort of support we need to have to be more effective? So, well, as I said, in rescue operation, this could be at the national level, but also at the European level. So what sort of laws, what sort of improvements we could make to this?
We can say that for the Italian Red Cross, for example, especially because we are not involved in the rescue operation, but we are involved in the period of quarantine of those arrive in Italy.
This is very, very sort of up-to-date topic. So, okay, so yes.
Yeah, but we can say that in a certain way is the same, because the period from the rescue and the period of quarantine is really in the framework of the time is really small, because people are rescued sometimes in the sea and then they move on the quarantine boat, for example. And what we do as a Red Cross in terms to support and protect the people and to prevent the separation is the Restoring Family Link service. So what we do is firstly collect all the cases of separation among family members. Of course, separation, as already said, could be mean a different option. We can have people that probably are separated during the journey from the country of origin, or sometimes could also happen that people are separated on different quarantine boat or different reception center. So as Italian Red Cross, we collect all the information from the people in order to support them in the reestablishment of the contacts. So this is one of the activities we do. Sometimes, as already mentioned, people is missing because probably is died in the Mediterranean Sea. And this is something that unfortunately we collected a lot of times. What we do is to support all the family member in the procedure that could be that is involved in the identification procedure. So we when the situation is possible, we speak with all the people to collect some information, first of all. So we try to understand in that specific circumstance who were on board of that small boat, to understand if the person was trying to cross the border, or if the person, for example, is still in Libya, because sometimes we don't know, because around the missing of a person, we don't know how many aspects are there, because sometimes the family member in the country of origin do not know about their loved ones for many reasons, because the connection is not like in Italy, is not like in Europe. The telephone mobile is broken, there is no Wi-Fi, the person are in jail, or sometimes the person are arrived in Italy, but they do not know how to restore the contact. But especially in case of missing in terms of victims of shipwreck, we collaborate also with some forensic institute to accompany the family members to the collection of DNA sometimes, when of course we can compare the DNA. So is really interesting, but at the same time really challenging, because as you may imagine, during a shipwreck, sometimes the body is not, there is not the body, for many reasons, because sometimes the body is not recovered, or because the sea totally destroyed the body of the person. So you can imagine how it's difficult for a family members to accept that they will never know if the body of a loved one is died or not. That's why for us these topics of missing person is extremely crucial, because it's extremely difficult also to support in the whole procedure the family members since the beginning. So since the collection of the bad news, I don't know if my family is alive or not, till the end, that sometimes at the end we are able to provide an answer, but sometimes no. So it's really important to provide the right psychosocial support to that person or to that family. So I don't know if I gave a proper answer to your question.
Absolutely,
but...
absolutely. wait 1 second, because maybe some other participants academics, NGOs, they have some questions. I was hoping that I have another one if nobody comes forward, but I really want somebody to come forward maybe, and some other questions. So I'm sure that there is, well, the next speaker is a professor from York who is, no, I just, I'm only telling that he is, well, he advocates and he works as a human rights defensor and so on. But his recent research was about exactly COVID-19 in the area, in this area. So I have a short question. So how about the vaccines? Would they be vaccine? Well, do you know something about it? Yes, I'm talking about migrants. I'm talking about, yes, because you were talking that you were saying that you deal very much with the quarantine. So I'm sure that this discussion is on. So how about vaccination? Well, I believe that it would start with vulnerable groups, but in general, the vaccination of migrants.
Up to date, we don't have information about the vaccination of migrants. I think that this is included in a bigger program because in Italy in this moment we have like different categories of people that are receiving the vaccine based on the priority and on the specific health condition. In this moment, we registered that in any case, all the migrants arriving, the percentage of people with COVID is not too high. And in all the cases, they do not have any symptoms. So I think that this is a first important point in to imagine a priority to provide vaccine in this moment. So I think, but it's a decision of the upper level. So I really don't know in this moment, but for sure in this moment what we are providing is the period of observation to understand if per person arrived are positive or not through the quarantine. But I don't have any information in this moment about the vaccine of the migrant people.
Okay, just another thing, and if you could say something about the quarantine and separated families, because how it happens. I think that this
of course
what you mentioned that you deal with this. So separation, well, in the time of quarantine, one is positive, another is not.
Of course. We adopted, we can say, guidelines specifically on the period of quarantine to maintain the family unity. In particular, for those arrive on the quarantine boat, but in general for the quarantine, because sometimes it's possible to do the quarantine also on the land, so not only on the boat. And not only for migrants, because this is really important to underline. The Italian Red Cross provide to all the Italian Red Cross volunteers specific guidelines to maintain the family unity in the context not only of migration, but in general for those, for example, are in the hospital, or for those are not able to maintain the contact with family members that are isolated due to the COVID. But in particular, to go back to your question, in the quarantine boat, we collect all the information from migrants, inform them to the possibility to approach the Italian Red Cross to restore or maintain the contact with all the people that traveled with them during the journey. Of course, it depends on the circumstance of separation, because we have different tools. But for example, the simplest example I can provide is, for example, as you mentioned, if family members are arrived in different boats, so we have special staff dedicated for the restoring family links in each boat. So they speak each other, and it's possible for us, for example, to locate one family member in a place, one family member in the other boat, and at the end of the quarantine, we are able to restore the contact and to facilitate, for example, the reunification. But sometimes also during the permanence on the boat, we try to collect information to understand if among the people on the boat there are family members that during the first registration they do not inform us of the family of the familiarity, and then they also understanding that Italian Red Cross is there for them, so to support their family unity, we day by day we are able to collect, to understand if there are some family ties to restore or to facilitate in the reunification.
Any other questions? I'm sure that there are some questions. Maybe I'm not waiting enough for those questions. Because I have another one. I have my question is, how it is decided who has a quarantine on the boat and who has a quarantine on land? So how is decided? Who decides this, and what's the percentage?
In this moment, we can say that there are some specific condition of health that does not.
Groups should be.
We can say that in the big framework of vulnerability linked with migration, because of course each of those persons are vulnerable, because the journey is an experience that of course expose the people to a vulnerable condition. But among of them, there are some specific categories that do the quarantine on the land. For example, the pregnant woman, or the unaccompanied foreign minors, or all those people who have specific vulnerabilities that that suggest the permanence in a different situation, like for example to stay on the land. But in any case, is an official document that the Italian Red Cross and the ministry, the government decide. So it's not there is not discretionality in this. There are specific rules for those with particular needs and particular health condition.
Excellent. Any other questions? I think that this is very interesting, and I think that, you know, in the morning maybe they are all very shy, because in the afternoon, you know, it always comes a little bit more lively. There are too many questions, but in the morning, so nobody has a question. So only me. I'm sorry, because, you know, just like I'm monopolizing this platform and I shouldn't really be doing this. So who has some questions? Well, so I would just explore, I would love to explore this more, but obviously I cannot, I'm still waiting. It may be maybe somebody will come forward. No? Right, so this is exactly exploring vulnerability during the quarantine time is really interesting, because here we can see that it's sort of ad hoc situation, because, well, we could not be really prepared. Maybe 1 year later now, we are a little bit more prepared now than we have been, but we were not prepared to this pandemic. So I think that this vulnerability and the issues should appear even more sort of acute in this situation, because well, probably vulnerable groups did not get at the start what they should be they should be getting. Anyway, Dr. Belasai.
Yeah, it's right, correct.
So thank you very much. It was very interesting. It was a little bit, this is what we said, it's really interdisciplinary. We really want to have the practical views, the problems that maybe we simply do not realize in our academic life. And now, and then stay with us if you can, join later on if you can, and please do stay in contact and collaborate with us.
Of course. Thank you again, and good luck for the next interviews.
Thank you very much, and our next speaker is Professor Martin Jones. He is from the Center of Applied Human Rights. He is a very active activist, if I can say, and human rights defender, and he will talk about vulnerability within refugee recognition. Hello? Ah, yes. No, I was afraid that something got wrong. So vulnerability within refugee recognition regime outside of the EU, the case study of UN High Commissioner for Refugees. As we said, this, although it's in the framework of Jean Monnet, but we know very well that we really don't limit our research or our discussion to the EU. Rather, we place it we place it in context. And
perché ora lo faccio online. Dal 12 aprile con Marziale, l'avevo vinto.
Antonina,
ho la borsa, prima che me la...
Antonina, we can't, I cannot go with the presentation, right? So, so the issue is that this is a very important subject, and I think that we also really, maybe we don't put enough emphasis on refugees, because we always consider that they are finally among the migrants, the most privileged group. So, Professor Martin Jones, have I introduced you enough?
Yeah, I think that's plenty, Katarzyna. Thank you very much.
Thank you very much for being with us, and I know that you are very busy, so we are delighted.
No, it's a pleasure to be here and to see all these, to meet some new colleagues. So it's wonderful. I mean, I guess I should say at the outset, I'm going to be talking, as Katarzyna says, looking at how UNHCR, both from a policy point of view as well as operationally, deals with or confronts the issue of vulnerability obviously dealing with the population of concern that it deals predominantly with, which is refugees. And so it's kind of a case study of UNHCR, necessarily, other than its policy interventions, obviously outside of the European Union. So I'm going to give you a little bit of background on myself, I suppose, and where I'm coming from in making this intervention, and then provide a little bit of history about UNHCR's policymaking on vulnerability, look a little bit at its operational practice with respect to what I call its role in the refugee recognition regime, and I'll unpack exactly what I mean by refugee recognition regime later. And then close with a few comments. As Katarzyna said, I've been working with some civil society organizations, predominantly legal aid organizations, to adjust their practices to respond to the pandemic, both in terms of their own services, but also to better support the populations that they serve, the asylum seekers and refugees, predominantly in the global south that they're dealing with. So I'll close with a few words, just reflecting upon the topic of vulnerability in light of the current situation. I suppose the first thing to say is that my work generally, I'm a lawyer by background. I did some, I came to academia after a history of practice in the Canadian refugee status determination system. And so I have some experience of how that system began to understand and respond to particular vulnerability within a national asylum system, particularly how it began to deal with gender-related issues and claims in the early to mid-90s. But more of my academic work, and certainly my recent practical work, has been working with, as I said earlier, legal aid organizations in the global south, mainly in the MENA region, so Middle East and North Africa, but also in South Asia and Southeast Asia. And so I come to this talk kind of engaged in jurisdictions which aren't known for, I mean, not putting Canada aside for a moment, aren't known for having national asylum systems, where UNHCR is basically a surrogate state and providing for refugees, including performing in most of these cases the key role of refugee status determination. And so one of the things I want to look at is how UNHCR responds to assessing vulnerability within that process. I suppose for those of you working within the European Union context, I guess I have to defend my choice of case study a bit. And it's just to say that UNHCR is obviously a significant actor. It performs roughly 10% down a bit now, but I think it's 5% in the most recent numbers, but like on average, historically, anywhere from kind of about 8 to 12% of that receives that number of new asylum applications every year as a global percentage of the new asylum applications. And plus or minus, it makes that a similar range of the decisions and outcomes. It has an operational mandate to perform refugee status determination in a shrinking number of states, but it's still now performing RSD in about 60 states, a little bit more than that. And obviously beyond that, it plays an active role in influencing, or trying to influence, I guess I should say, both national and regional policy development. And so every time the European Union, various institutions within it come up with new proposals, the UNHCR is intervening, as well as obviously taking a fairly active role in some of the recent jurisprudence coming out of the European Union judicial institutions. It has recognized that in the context that I'm talking about, it struggles with vulnerability and with, I mean, as it says more kind of euphemistically, ensuring comprehensive refugee protection and robust and long-lasting solutions for refugees. Yeah, so it recognizes that in the places that I'm talking about, there is no perfect, and it's trying to make it better or at least good rather than the best. I guess the opening thing to say about the policy context is, well, I suppose it's background on this idea of vulnerable asylum seeker, vulnerable refugee. The first, I guess, is to say that similar to migrant, perhaps, there is a certain concept of vulnerability embedded within the category, right? So refugees are singled out both because for the same grounds as migrants, they are not nationals of the state that they're in, and so therefore seen as needing particular attention because the legal frameworks and practices and policies may otherwise exclude them, for example. But also in the case of refugee, there's a particular vulnerability, obviously, that arises specifically out of their risk of refoulement, out of the risk of persecution that gave rise to their flight, or at least that maintains their exile. The second thing, I guess, is to say it's a relative term when we're talking about vulnerability. And I think Federica made this point as well. We're talking about individuals as a population, and a group of people who as a population, as I said a moment ago, are identified as being at risk or suffering from particular obstacles to their enjoyment of their rights. And so when we're talking about vulnerability within this population, we're talking about a relatively higher level of risk or vulnerability. And then I guess the final thing is that and I think some of the later presentations probably will better deal with this, but I guess just to acknowledge that, as I said at the start, I come to this from work on other topics, not directly working on vulnerability, but that I struggle with the kind of conceptual distinction between labeling people as vulnerable individuals and rather approaching it as individuals in a situation that makes them vulnerable. I think for all sorts of broader kind of ideological reasons, the latter is probably the preferable way of approaching this topic. And yet my sense is from the policy review I'm about to go over with you, let alone the operational approaches, that is often the former approach that we're implementing. And so I guess recognizing at the outset that both I find some of the language a bit difficult, as well as some of the concepts a bit loaded. I guess the first thing to say is that there's no policy on vulnerability per se, although if we look at UNHCR's primary policy mechanism, it's conclusions on international protection, which are produced on an annual basis by its executive committee and have been produced probably for the last close to 50 years of its existence. So there's no individual executive committee conclusion that addresses comprehensively vulnerability, but it is used, it is a frequent term. It's used in 32 times in probably about half as many executive committee conclusions. So it is one of the drivers of its interventions in international policymaking. When we look at within the usage of vulnerability, what types of people, what categories of individuals are categorized as vulnerable, there's probably not a huge surprise, and this probably maps relatively closely to some of the, well, certainly you'll see a repetition between the list I'm about to give and the European Union's, for example, definition. But women, children, and more recently youth, so kind of a broader category, including young adults. The elderly, shockingly recently, I mean, it technically dates back to the 80s, but only in very passing references, only really seriously paid attention to much more recently, although probably not that surprising in line with international human rights law, very belated kind of attention to the elderly. In particular, for a long time, and probably the most mentioned group is victims of either sexual abuse and exploitation or trauma and torture. So broadly speaking, the category of victims of torture, sometimes lumped in with women and girls at risk, but more recently separated out. At various points in time, other categories have been identified, and tying back to Federica's presentation, I mean, stowaways, individuals in maritime rescue situations have been recognized as being particularly vulnerable. And similarly, those who have been intercepted at sea, I mean, it's a similar kind of situation, have also been recognized as vulnerable. While most of these categories are in the policy documents framed in fairly static terms, I mean, there are a couple of mentions of note which recognize the dynamism within the categories. So recognize that, for example, vulnerability can be created, for example, through poor reception arrangements. And this is in a context where UNHCR is itself managing many of the reception arrangements, but also over time through protracted refugee situations, particularly in camp-based situations. And both of those recognitions of the kind of the dynamism of the category are more recent. Interestingly, at least in the high-level policy documents, there's no mention of vulnerability linked to sexual orientation and gender identity, which I think says something about the international politics of the executive committee, which is a state body. Although in much of the operational guidance, particularly the recent operational guidance, including in regions where sexual orientation is still controversial as a issue. For example, in the vulnerability assessment framework in Jordan, they specifically single out SOGI issues, broadly speaking, as producing vulnerability. Once vulnerability is identified by the policy guidance, I mean, there is a question about what to do about it. And I guess there's 4 different ways that the documents suggest that the response is either four different domains. One is in relation to reception arrangements, recognizing that there's a linkage between vulnerability and potential sexual and gender-based violence within the reception arrangements, produced by bad reception arrangements. Secondly is in registration or what they call documentation. The third is in refugee status determination, and the fourth is in resettlement. And so that will be what I would talk about for the rest of my presentation. I mean, and I guess together those 3, the documentation, refugee status determination, and resettlement, are what I call the refugee recognition regime, borrowing the term from Catherine Costello. These are the 3 domains where UNHCR, in a sense, labels or allows access to the label of refugee and brings people and communities within its protective mandate. And I think more traditionally we'd focus just on refugee status determination, but the broader idea of refugee recognition acknowledges that actually it's not just through formal individualized status determination anymore that UNHCR is designating individuals and communities as peoples of concern, but it's through this broader range of labeling activities that give access to various types of protection. I guess whereas kind of it's easier, although I gave a bit of a whistle-stop tour through it, it's easier to identify what international policy is when it comes to its operational practices in those 3 domains. In the refugee recognition regime aspect of UNHCR, it's much harder, largely because those operations are developed at a much more local level. So there's not even really regional approaches with respect to each of these. The standard operating procedures are usually developed at, if not a country, even a sub-country local field office level. So it's much harder to try and make general comments about how vulnerability is approached, other than to say that the guidance that UNHCR does produce for its global refugee recognition activities does say that the procedures should be in place to identify and assist vulnerable asylum seekers. Yeah. So it acknowledges that, even as it leaves to the particular field offices flexibility in figuring out exactly what that would look like. The operational guidance also does acknowledge that the ways in which vulnerability is identified or not identified and is accommodated, mitigated, can result in, have other consequences for the legitimacy or the integrity of the refugee recognition regime. So kind of there's a recognition that this is important not just for the individuals, but actually for the system that UNHCR is developing. In terms of the policy guidance about how the standard operating procedures should occur, it's basically, there's a few specific ways of responding to vulnerability that are identified. The first is in trying to create processes to identify vulnerability. And I'll come back to this particularly in relation to COVID, because that's messed up, I think, quite a lot of the normal processes for identifying vulnerability within the intake processes. The second is the special training of staff to identify and to better accommodate the particular needs and situations and signpost to services of particular vulnerable groups. And the third is the provision of additional services to vulnerable groups that may in some way be able to mitigate their vulnerability. And the archetype of this is counseling to survivors of trauma, or shelter and some form of sheltered accommodation to unaccompanied minors, trying to somehow address, to the extent that UNHCR is operationally able to, the core, one of the core dimensions of the vulnerability or impacts of the vulnerability. Within UNHCR's refugee recognition regime, there is a role for civil society in addressing and advocating for vulnerable individuals. And this largely comes down to assisting UNHCR in the identification of vulnerable individuals. So in most standard operating procedures, there are mechanisms whereby civil society organizations, service providers can inform UNHCR of having identified a particularly vulnerable individual or family. And then that will then produce the various kinds of priority processing or access to resettlement or whatever the local particular remedy suggests for that particular vulnerability. Having said that, obviously, civil society often suffers from the same cultural and structural biases that that UNHCR suffers from. So it doesn't necessarily help do the identification and referral process very much, as much as it probably should. And the classic, the recently kind of pointed out example of this is in relation to sexual minorities. I mean, individuals with individuals who have risks and often claims related to their sexual orientation or gender identity. And recent work by organizations like ORAM has suggested that part of the problem in relying upon civil society to advocate for these individuals and identify these individuals is that civil society has the same kinds of, for example, homophobia, the same kinds of biases within a particular operational context that both UNHCR as well as the host community might. And so simply creating mechanisms for civil society to help UNHCR identify individuals who are in vulnerable situations won't necessarily do anything to meaningfully address the problem. I'll say a few words about resettlement before closing on saying a few closing comments about the impact of COVID. I guess resettlement is that third element of this refugee recognition regime. It is where not only UNHCR typically, but also a third country, a resettlement country, a European country, America, Canada, Australia, New Zealand, and a range of other countries also recognize somebody as a refugee and move that person from a country of first asylum or asylum at least, typically in the global south, to somewhere else. Again, typically in the global north. It is a durable solution in UNHCR's language. It is the least practiced durable solution, with less than 1% of refugees having access to it, and in practice, actually a lot less than 1% of refugees having access to it. It obviously, as a durable solution and as the least practiced one, only occurs after there is no prospect of voluntary repatriation or local integration. It typically happens in places where even where refugee status brings irregularity. And the interesting thing when we talk about vulnerability to look at resettlement and how that works is that it's almost all vulnerability linked. So all of the categories that we'll see in a moment, the generic categories, but also the country-specific categories are linked to vulnerability. There's 5 big categories, and I'll just go through them quickly. The first is legal and physical protection needs. These are individuals at heightened risk of arrest or deportation. These are sometimes individuals who have already been arrested or have had a history of arrest, individuals who in a sense are facing problems either within the country of asylum or they risk being expelled from the country of asylum. Survivors of violence and torture, obviously, and individuals with medical needs that cannot be met in the country of asylum. And then women at risk, so who have protection problems particular to gender and lack effective protection, normally provided by male family members, to use UNHCR's formal definition. And then finally, individuals who are vulnerable and who require family reunification. And this, I think, ties in a bit with what Federica was saying about the IRC's role in some of its operations. Here, the vulnerability arises out of the dependency relationship, which often involves children, but can also involve older members of the family as well. And UNHCR interestingly flags this as its area of resettlement, where there's the most common, most commonly worries about fraud. I think the worry with UNHCR is that there's not necessarily in many cases definitive documentation about who's a member of a family, and so it is open to abuse by individuals seeking resettlement to reunite with fictitious family members. Ironically, I think in practice, actually, some of the fraud problems come about because of some of the restrictions on access even to registration within the refugee recognition regime, which then produce stories at that end of the refugee recognition regime that then catch up with people by the time they get to the resettlement. But I can say more about that in the questions. Children, adolescents, and elderly are not per se recognized, but obviously they can be considered under other categories, most obviously under the family reunification category. And as I said earlier, I mean, in a sense, vulnerability is a requirement for all 5 categories because all of these individuals must somehow be unable to locally integrate. So there must be some sort of legal, social, cultural, linguistic, economic vulnerability. Yeah. So finally, I guess, as Katarzyna said at the start, and as I mentioned, I've been doing some work with legal aid organizations trying to think about what the pandemic has done to their operations and the communities that they serve. The first thing I suppose to observe is it's not an egalitarian pandemic, and perhaps there's no such thing as an egalitarian pandemic, but I think all of us can very immediately understand that the pandemic has exacerbated inequality. And I mean that far beyond the migration field, I mean across society more generally. Yeah. The second thing is obviously that non-nationals have been particularly deeply affected. The closure of borders, preventing mobility, reunion, but also from their exclusion from national responses. I mean, many national response frameworks take no account of non-nationals. And even if they do, they face cultural, geographic, linguistic barriers to access. Beyond that, obviously, in many contexts, migrants and refugees and asylum seekers are now seen as increasingly in some of the popular discourse as vectors of disease. I mean, this has long been a discourse. This is not new, but as populations have been locked down, these individuals who are seen as less controllable or having been less controlled are seen as bringing with them risk. And so many countries during the pandemic, they have been targeted, making things worse. I mean, from a pandemic point of view, in a kind of an anti-public health way, but that's just the reality. In the refugee recognition context, I mean, the pandemic has also altered the way that refugees access protection through UNHCR and created new barriers to identifying vulnerability. So physical interviews, for example, have disappeared. UNHCR has closed many of its operations. There's no in-person interviews. Much more is done by paper, by telephone, and occasionally now they've started up some video processes. But all of these prevent many of the ways in which vulnerability is identified from happening. One of the ways that UNHCR in its guidance suggests that, for example, women at risk be identified is through signs of domestic violence. I mean, which probably is not the best way of identifying victims of domestic violence generally, but to take that just one example, that is no longer even possible with offices being closed and no in-person interviews and video interviews not being used, let alone the fact that men control telephone access and because of that will be present during any time that a female refugee claimant is using the telephone to talk to UNHCR. So I mean, all of these types of changes in how UNHCR is practicing its and delivering its services are affecting how vulnerability is screened. Yeah. It has also obviously exacerbated existing vulnerabilities. So this goes back to the point about vulnerability being dynamic. As I said kind of earlier, some of the ways in which UNHCR probably fairly ineffectively identifies women at risk have been disrupted. But beyond that, there has been heightened risk of women and girls generally. There's been kind of an epidemic, along with the pandemic, of domestic violence that's been reported. So, so there's increased vulnerability there. The elderly, because of the pandemic, are more at risk. The learning disabled, I mean, as we're going through this pandemic, we're realizing purely from a medical point of view that there are new segments of the population that may be at risk, who may have already been at risk in different kinds of ways, but who are at increased risk because of the pandemic. And it's also created new vulnerabilities. Suddenly, individuals who are employed in particular occupations, service delivery occupations, are more at risk, for example, of the pandemic. There are particular sectors that have been closed down, where if a refugee or asylum seeker is employed in that sector, suddenly they will be without a job, typically without access to any of the furlough schemes or whatnot that happen, and because of that, thrown into poverty. So I don't have any answer here. It's just a comment that I think one of the troubling aspects of the moment is the way in which the pandemic has disrupted our ability to respond to vulnerability, and has also created new vulnerabilities which we have yet to catch up with. Yeah, and thank you for your patience. That's it. Thanks.
Thank you ever so much, Professor Jones. Thank you so much for this very insightful talk. I just would like you to ask the question, because obviously I have many, but I will just wait. And yes, Giuseppe and Romero, one small second. How you have to, your microphone is down, so you have to, yes. Yes, please, with the great...
I just want, excuse me, I just wanted to applaud to Professor Jones. It just was an applause, not a...
right,
I was not raising my hand.
Oh, sorry, I thought it was a hand. I thought it was a hand.
No, it was just my clap.
Okay, so it's my mistake, because I don't recognize the sound of this new way of intervening. Okay, thank you very much. Anybody wants to ask the question? Carola, Professor Ricci, absolutely, Professor Ricci.
Sorry, first of all, thanks both to Katarzyna for organizing the event. It's very interesting for me. And both to Federica and Martin, thanks, especially for your intervention and mostly for what you do, I mean, every day. And second, maybe the question, it's not probably a question, it's a curiosity, because I totally agree with Professor Jones when he's saying that we should need a more robust, long-lasting solution for refugees. And to this extent, knowing also your experience in the Canadian environment, knowing kind of well let's say the experience of the private sponsorship model that actually worked kind of well in the Canadian, that's in Canada, maybe in the 60s, now still continuing. But I don't know if you know that in Italy, 5 years ago, they started applying this model to a new project that it's an hybrid project. It's an hybrid convention agreement, I would say, having from one side the NGOs you were referring to, but they're mostly religious NGOs. So about the bias you were referring, there are some. But at least they were the one, and they are the one who are sponsoring the coming of legally income of families and I would say vulnerable people. But the definition of vulnerability actually is, if it is found not in international law. So the reference is not general to international law or UNCHR guidelines, but they do define themselves in order also to apply the same practice and knowledge they are developed in camps, mostly I would say in Lebanon and Eritrea. And now the numbers after a few years, they are kind of high. I mean, considering that it's just one initiative, there are 3,000 people who reached Italy till last year. With COVID, everything changed, as you were saying. But the point is that they had difficulties in applying existing law to help these people, because they were coming from Lebanon, the first 2000, and they foreseen as a legal basis to come in an LTV visa, so a temporary visa with a territorial limitation. Contrary to what happened for the Canadian, they didn't have this definition. So they could enter the Italian, and only Italy actually, the Italian territory. And once there, they had been helped by legal practitioners and other associations, not only the religious one, those who actually joined the project, asking for protection. And then there's the bias, because sometimes the two categories doesn't coherence it. And the point is also that after the case law delivered by the European Court of the European Court of Justice in X versus X and X versus Belgium, where actually they said that states they are not obliged to let people come in through LTV visa, because actually the only vulnerable people covered there are those who are going to stay for 90 days or at least in a period of 180 days, meaning that the long-lasting protection is not foreseen. And so my question is also looking at the future and what they are developing at the EU level, but also asking to practitioners and those who really know the situation. Do you think that such a model, so the private sponsorship, could be functioning also at the European level? I do believe that's a very good one, at least one of the possible legal entry for vulnerable people in general. Not limiting it to those that are covered by the Geneva Convention, but not only those, also those covered by the directive that never was applied in the past for big fluxes in case of emergency. That I know, as far as I know, they are rephrasing, but still now there's no legal framework for this, unless the states do ask for the application of humanitarian law and discretionary power in order to determine whether they want to help or not. This is something that still now is possible, so the states are called upon it to declare that they want to help, and they cannot be sheltered by EU law, not even by EU Charter, because the Charter cannot be applied if EU law doesn't exist. But still we have the European Convention of Human Rights imposing states to do that. In my vision, people that are asking help to a diplomatic, for example, premise in Lebanon or wherever, actually are subject of the jurisdiction of a state, and such state has to apply the standards of protection provided for example, by European Convention of Human Rights, namely Protocol 4, imposing the non-refoulement. So I'm very, very happy if you could give me your ideas, also to Federica if she has time, but I don't want to, again, I wanted to ask before, but since I wanted the students to raise hands, so I don't know, maybe Katarzyna, you can still open the questions to the students and then leave this as a last response, I don't know.
Well, just yes. So let's wait. Let's wait. If somebody, you're absolutely right, because we also, it's very important that exactly our students are here and they follow the debate, because it's a very important, not only problem, but it's an important element of any course on migration. So do I have any students? They are too shy. It's probably too early, but let's wait. So will I have somebody who is less shy? Let's wait. Maybe do I see them all? If you see, yes, no. No, I thought that I have seen somebody, but no. Here, no hands. So Martin, go ahead, and then I have some, but I don't want really to monopolize this, you know, the platform. There is only me asking questions. So I just address Professor Ricci's comments, and I will have some questions, unless students will have some. So I will give my, you know, my question, my time to them. Okay.
No, Carola, I mean, wonderful question. And the short answer is, I don't know. So, I mean, you know, I think kind of these are these conversations where if any of us had kind of a complete answer, the world would be a much better place. But inevitably things don't have quite a simple or succinct answer. And you know, I guess I can share with you my experience and reflections on, for example, the Canadian resettlement process, and you can maybe take whatever of that is useful and apply it to the EU context, about which I'm a lot less aware than you are. Canada does like to and has been very actively in recent years, probably the last 10 years or so, has been promoting its private sponsorship model. And you know, as a Canadian, putting aside my, you know, practice as a refugee lawyer there, it is a big part of the national identity since the Indo-Chinese crisis. And I think it is actually genuinely something that works. I mean, the story, I don't want to use up Katarzyna's time or the students' time, but the story I always say is that my parents live in a very remote part of Canada on a small island, which is predominantly white and has been settled by, I mean, for want of a better term, ex-hippies since the 60s. So a progressive community, but a fairly insular one, and a very old one. I mean, the average age on the island, I mean, is, yeah. Let's just say they're getting the vaccine right now, thankfully. So, you know, they sponsored, during the Syrian crisis, they sponsored a family of refugees. I mean, out of the blue, just they thought it was a good thing to do. They got involved, and I mean, God help the Syrian family that landed on this white Christian island, you know, with, you know, filled with grandparents, as opposed to other children. But you know, it is that kind of grassroots engagement with refugee protection, which I think has been a key part of its success. You know, so it is even in Canada, though, to this day, predominantly. I mean, there's a couple of elements to the private sponsorship program. There's the so-called groups of five, which is the way my parents' island organized. It's kind of a spontaneous group of 5 permanent residents or citizens that can sponsor a refugee family as long as they indicate that they have an integration plan. The large, well, probably the bigger part, it's a little bit more than half usually, is the so-called sponsorship agreement holders, who are the more professional organizations that bring in on a regular basis a quota. Everyone's given a quota under their particular sponsorship agreement. Those are predominantly religious-based organizations, even if some of them aren't overtly religious-based, but they've come out of particular communities, religious faith communities. So even if their current incarnation doesn't look like it's religious, everybody within it is an Anglican or a Mennonite or whatever the particular faith history of that group has been. So there is a big part of that. I mean, and that obviously has a lot to do with the linkage between the ideas of sanctuary and faith, you know, across the big faiths of the world. I don't think it's a particularly Christian aspect, although in Canada, that's the way it plays out, and it has the same kind of biases. There are still access problems. So Canada changed its rules so that UNHCR, refugees who resettle now have to have recognition as such by UNHCR, which means that if you're from a place where UNHCR doesn't or isn't allowed to recognize refugees, or has a quota placed upon, or an ethnic distinction put upon it by the host country, that those individuals actually, there's ways around that rule, but those individuals struggle to get sponsored. So and the reason they did that is exactly, it ties in, and the reason I mentioned that is because it ties into what you said about the idea of kind of asylum on diplomatic premises. The immigration officials in Ottawa were worried that if they get they recognize that if they got UNHCR to recognize individuals, they had some control, because they have quite a bit of control on UNHCR. Whereas if they allow anybody to file an application with the local embassy, they have much less control. So it was a very deliberate policy change. I mean, it resulted from some litigation I was involved in kind of a backlash kind of effect to the litigation that we won. Yeah, there's aspects of the program that are less open and welcoming and more controlling than you'd think from afar. I guess the only final thing to say is that Canada doesn't have all refugees who are resettled who arrive in Canada upon their arrival become permanent residents. So there's none of this kind of in between short-term visa categories generally. Obviously, asylum seekers who spontaneously arrive and go through the asylum system are in this short-term category, but otherwise they then transition to permanent residence, which in Canada effectively means that you're both temporally as well as practically, for most respects, equivalent to becoming a citizen. Canada is considering introducing basically, I think what in the European context you call a humanitarian visa. I mean, so it'll be interesting to see how they then struggle and try and draw lessons from the EU about exactly what the problem is that you're saying about the mismatch between the criteria for the shorter term category and the criteria for the longer term category, and worries about people switching and wanting to encourage or discourage switching between the categories. And so one of the things that Canada right now is reviewing as part of another policy that has to do with human rights offenders is the introduction of a humanitarian visa. So they're about to confront the part of the problem that the EU is trying to get over shortly. Yeah. And I think that was everything I have to add, other than to say, yeah, I don't have a simple answer to how the EU can launch a resettlement program, other than to say, obviously, the numbers of refugees resettled to the EU have dramatically increased over the last decade and a half, and that's been a very impressive response. I'm not sure UNHCR has quite met its 20,000 by 2020 target, which was its kind of advocacy campaign for a number of years, but it must be close. I mean, 2020 obviously is a bad year to nail your flag to in retrospect, but the numbers across the board were down last year. So, but yeah, no, that's been an improvement, and perhaps with some sort of private sponsorship model, there'll be more room for a bigger increase in the numbers.
Thank you very much, Professor Jones. Well, I will ask the questions, but because we are 10 minutes late, so maybe the answer we will just consider later after Professor Nath talk, because if we don't manage, we don't manage, but we need to carry on. So my questions are, so I think that that international perspective is extremely relevant for the EU. I think that we cannot talk about EU ideas without international law. So every time you tell me, well, this is not the EU, it doesn't matter, because we really needed to see it in context. Then definition, I thought that what's very important about the definition, it's not what is in it in the EU definition, but what is not. So this is you underlined in your talk. You talk about a new vulnerability, unemployment, poverty, and so on. So this is a very interesting issue as well. And the last issue, I just would like to know how during the COVID time you do the interviews and all this stuff related to refugee status determination. So is it, well, shall we say that it's obviously slower, but is it not impacting on asylum seekers and on their situation? But okay, this is what I don't want to answer now, because we need to go ahead with Professor Na, who is also a member of Center of Applied Human Rights defender, and she had collected millions of grants. I really don't know how she's doing, so she's very, very successful in the new areas related to her projects, her teams, and so on. So she is going to talk about protection of vulnerable groups in migration through alternatives to detention advocacy. Another very interesting topic. So the floor is yours, Professor Na.
Thank you very much, Dr. Katarzyna. So it's a pleasure to be here with you today. I'm going to share my screen because I've got some slides to go through with you. So I hope you see them fine. And I just want to say that actually James Lewis, who I wrote this paper with, is actually on the call as well. So James, I also welcome your thoughts as we, sort of respond to any of the questions. So this research came out of a question posed by the International Detention Coalition, which is an international network of organizations that have been advocating to limit and to end immigration detention globally. And actually the IDC has been at the forefront of advocating for alternatives to detention. And over the past 10 years, they've seen evolutions and patterns that have become worrying. Although they are one of the main proponents of alternatives to detention, they also realize that they realize some of the issues around the use of this advocacy and the unintended effects that it has been created. So they got James and I to work on this piece for them to really look at what it means, what are the issues with alternatives, and what are the arguments for alternatives, as well as some of the criticisms. Yeah. So this is what I'll cover in the conversation today. Really have a look at what the definition of alternatives to detention mean. And some of the issues around, the way it's conceptualized, some of the arguments for, as well as criticisms of alternatives to detention. So I think that the first thing is that there isn't one particular established legal term that's used. The IDC, this is one that its members uses, which is any legislation, policy, or practice, whether formal or informal, aimed at preventing the unnecessary detention of people for reasons relating to their migration status. So captured here globally would include migrants as well as refugees in contexts where refugees and asylum seekers are detained. In a lot of places they're not, but for some people, especially as their asylum claims are being determined, some of them are held in detention. The European Alternatives to Detention Network draws upon the IDC's definition and simplifies it to this definition. Yeah. The aim of the IDC was, as I mentioned, really to reduce the use of immigration detention. So in its early days, when it put this definition forward, its aim was really to look at non-custodial approaches. Yeah. Since then, the European Commission has also come up with a definition. So it uses a narrower, more specific definition. So a non-custodial measure used to monitor and or limit the movement of third country nationals in advance of forced return or deciding on the individual's right to remain in the member state. Yeah? And it gives some examples such as reporting, the surrender of financial guarantees or travel documents or electronic monitoring. I'll come to this definition again later because you'll see, as I mentioned, that there's a diversity of practices considered alternatives to detention, some more progressive than others. In the US, the Immigration Department there defines alternatives as mechanisms to ensure compliance and move immigrants through the immigration court proceeding without detaining them inside detention centers. So you'll see the first two definitions I gave in the earlier slide were a civil society perspective. in a sense, more progressive, more about liberty. Whereas the European Commission and the US Department, Immigration and Customs Enforcement definitions focus still on monitoring people and limiting their movement. Yeah. So what you see when you look at alternatives to detention, actually you're referring to a diversity of practices, some of which are more enforcement oriented, so that impose specific restrictions, particularly on the liberty and movement on people, such as frequent reporting. So, you have to come and report yourself every week, let's say, to the police or, to a designated office, or, in some circumstances, even the use of electronic tagging, right? Others, and this is more the civil society's option, focus more on engagement and case management. So they advocate alternatives to detention that focus on, close working with the migrant and refugee, on looking at their cases, interacting with them, helping them to understand what's happening with their cases, and placing people in community accommodation instead of custodial, or detention facilities. Yeah. So these are just some examples that have been listed by the Steering Committee for Human Rights. Some alternatives to detention could be registration with the authorities, temporary residence, case management, some with case management support, caseworker support, alternative family-based accommodation, residential accommodation, shelters, yeah, open reporting, designated residences, having a bail bond or a guarantor, or electronic monitoring as well. So I think one of the major arguments, that civil society actors, but state actors have also put forward that, in favor of alternatives to detention, first of all, is the cost savings. Yeah. And this is actually a really persuasive argument, because there is, obviously detention is very, very expensive. And several studies, like the ones listed here, say that, in some cases, the savings, De Bruycker and colleagues, for example, say that in Australia, you save up to 86% of costs. The European Migration Network in Belgium estimates that the savings could be 53%. Alice Edwards, highlights savings of 93% in Canada, 76% in the United States, even up to 98% in Australia. And Ariatani, in her review of pilots in Europe, said that, the cost per day of ATD pilots were even as little as, 3 to 4 euros in Bulgaria, So the costs of alternatives can be quite significantly different, yeah. But it's not just the cost of running or managing individuals. There are also other costs associated with detaining individuals in detention facilities. So in the EU, escorted deportations can cost states, about 1,500 euros per person. Assisted voluntary departures can cost around 300 to 600 euros. There's also savings to be made in alternative ways. For example, when there's litigation for wrongful detention, the litigation and compensation can be quite expensive when states are found in error of detaining someone wrongfully. And Ward estimates that the lifetime health costs of long-term detention could be even up to 15,000 euros per person. But of course, what is of greatest concern to civil society organizations is the human cost of detention, right? And there's so many repeated studies that show that the negative impact of detention on an individual's person's physical or mental health are quite tremendous, with long-lasting effects, especially for children who are detained. No, so it's really trying to avoid the human cost of detention that civil society groups have been advocating for alternatives to detention, rather than necessarily the financial cost savings, which is what convinces states. So what civil society groups have been saying is that it's really more humane and effective. Sorry, someone's phone is ringing. So it's more humane and effective. So, Otani, in her assessment of alternatives to detention, pilots in Bulgaria, Cyprus, and Egypt found that actually most of them still were engaged with immigration procedures, because that's the other fear of states, that, if we release people into the communities, they will just abscond, they'll just run away. So how do we actually know that they will come, we'll be able to maintain contact with them and be able to work through case resolution with them? Yeah. So she found that actually most people remained engaged, 86%, 25% achieved case resolution, and only 12% absconded. And then 2% in the end were removed, yeah, because their cases were rejected. Cases for protection were rejected. But what she definitely found was that if you did case management effectively, the beneficiaries themselves would also contribute positively to the resolution of their cases. Yeah. But she emphasized quite strongly that you have to treat the beneficiaries with respect and dignity. If you don't do that, then you know the trust that's necessary for beneficiaries to really fully disclose their circumstances isn't there. And so the trust is a very crucial factor.
No, se noi non la fai, ma non c'è una cura che si può fare al fegato.
I think somebody needs to mute, yeah, the mic.
Yes, this is exactly what I'm looking for.
Yeah, so she was saying actually in her review of case management approaches to alternatives, she was saying that it's really important to empower beneficiaries to stay active, to keep them informed, ensure they have access to competent legal assistance, but also often when they're dealing with the immigration situation, they have other practical problems they need to solve while they're waiting in the community. So actually the caseworkers also in the end have to end up helping them on issues such as, accommodation, healthcare, education. And as they accompany these beneficiaries on these issues, it helps to build their resilience as well. And she also noted that this case management approach can be adapted to other contexts and situations. Yeah. So it's actually a flexible method. It can be adapted to different situations. As I mentioned, one of the key concerns for states is the compliance rates with migrants. Yeah. So, actually several studies show that there is relatively high compliance rates between 84 to 99%. And other studies show it as well between 77 to 96%. Yeah. So yes, it's not a perfect 100%, but it's pretty high. There also have been criticisms to the use of alternatives to detention approaches. And the first thing is what I mentioned earlier, that there's no universal or consistent definition of alternatives to detention. So Bothworth, for example,
la bimba dovrebbe darti più stimolo
sorry, I think someone's
in teoria, no?
Someone's mic is not muted. So there's no universal definition. So there's little consistency in the rationale or even the application or the design of alternatives to detention programs. And it actually can be counterproductive to the goal of ending immigration detention. So Michael Flynn, who's been quite critical of the use of alternatives to detention arguments and programs, has said, states have exploited the paradox of alternatives to detention by developing alternatives that fail to move policy and practice away from detention. So there's actually a concern that alternatives to detention could be alternative forms of detention. Yeah. So Ms. Mack, who looks at these practices in Indonesia, say, what you call alternatives actually serve containment purposes. Yeah. And in the US, a network there says it can be another route to restrict and surveil immigrants and further alienate immigrant communities. So really the concern is that alternatives can increase the detention estate rather than reduce it. And some critical, observers say, well, actually, you haven't actually reduced the number of people in detention. What you've done is actually increase surveillance of people and increase restrictions on migrants. You haven't actually reduced the total number of people in detention, if that was your original purpose of advocating for alternatives. So Bloomfield, observes that, alternatives alone can't be effective by themselves, but what you really need to look at is the rationalization and humanization of the migration system. And you must also have increased transparency of detention practices alongside advocating for alternatives. Yeah. I mentioned just now that some of the more enforcement-based approaches focus on restrictions. And these are some restrictions that the UK government, for example, imposes on those who are given immigration detention bail. Yeah. So even if you're granted bail, you are subject to one of these restrictions, either regular reporting or attending an appointment or hearing. There are restrictions on where you can live. Sometimes you may have an electronic tag placed on you. You could have restrictions on your work or your studies, or you have to obey whatever other condition, and that is decided by the person granting your bail. So just some thoughts to offer.
Sì, diciamo che non lo
on
non puoi
use of
sapere però
alternatives.
questo, cioè non sei uno psicologo infantile, quindi che
Carissimi,
decidi che è meglio che
mettete
muore
giù
adesso
il
per il
microfono.
bene di tua figlia, non lo puoi sapere.
Tagina, se vai su participant in
Ah,
alto,
sì.
trovi mute all.
Ah, ma dopo come faccio?
No, dopo loro si possono riprendere la parola quando vogliono.
No, ma non trovo quello. Professor Ricci, sono tutti, ma forse adesso ha fatto, ah sì, disattiva audio. Ok, non lo so se l'ho fatto. Ok, Professor, no, I'm sorry for interrupting. I'm sorry.
No, not at all. So this is just my last slide, really. So I think just in summary, over the last 5 to 10 years, we have seen that there is definitely potential for alternatives to detention to reduce the harms associated with custodial detention. Yeah. But the reality is that they won't fix all the flaws in a migration system. So if you've got a very flawed system anyway, that unnecessarily detains people, then it's not going to fix that problem. What civil society groups have found is that advocacy on alternatives to detention have opened up spaces for dialogue with state authorities about immigration detention practices that didn't exist before. Because what often happens is that there's such opposing views on immigration detention that actually the space for dialogue and conversation isn't there. But advocacy on alternatives have opened up these spaces. Unfortunately, the merits and the demerits.
La prima dose di vaccino che mi ha fatto malissimo, in verità.
No.
Ancora mi sto riprendendo. Come sì, no,
Professoressa Caruso, dovrebbe chiudere l'audio.
muscolari, ossei, articolari, come quando c'hai la febbre a 40. Però la febbre non ha superato i 38 forse durante la prima notte, poi non ci ho più avuta.
Casina, is there a way of muting all participants?
I don't know, I'm trying to do it, but apparently, can you hear me?
Il giorno dopo mi sono
I can hear you, but I don't think the person who's speaking can.
È come una drogata.
I need to...
Ma non ero in grado di fare nulla adesso. Da sabato sto meglio, però insomma ancora più dolore.
Professoressa Fulvia Caruso?
Sì.
Scusi, deve silenziare il suo microfono.
Oh cazzo. Scusate.
Okay, it's done now. Should be done.
Okay. I just don't know how. I tried, but it didn't come. I tried and then okay, Alice, terribly sorry.
Okay, no. I just wanted to end with these last thoughts. Yeah. So really, when we assess alternatives to detention, we can't just jump on the bandwagon and say that it's definitely a good thing. It is something that can be a positive advocacy method, but only if it actually fulfills the human rights of migrants. And there are pros and there are cons for how we assess alternatives to detention, and we really need to focus on how it affects the rights of migrants. It's an obvious thing, to say when you say it, but then actually there have been, when we talk, I think one of the challenges is that there are many definitions of alternatives to detention. So sometimes you say something, but actually you're meaning something else, even as you use that term. I think the final 2 points really are that advocacy concerning alternatives to detention tend to focus on the concerns of states. So when civil society groups have said, look, it's cheaper, it's more cost effective, you won't have, you have pretty high compliance rates, people don't abscond as much as you think they were. Really, these are all concerns of states. And what there's a worry about is actually that states then say, well, if alternatives is very progressive and we know that it serves the human rights of migrants, then we will use it. but then that term gets co-opted by states and becomes used as a positive example of what they're doing for the human rights of migrants, when actually the impact on migrants is still negative. Ostensibly it looks like they're doing something positive, but actually in reality they're doing something negative. So there's also the last point. It's just that there continues to be debate about whether civil society groups should campaign for the abolition of immigration detention, even as they advocate for alternatives to detention. I think if you speak to lots of civil society groups, they are very, very concerned about the use of immigration detention at all. And ATDs are just an interim way of saying, okay, hang on, let's really rethink these practices. If you truly are very committed to immigration detention, can we look at least at alternatives, ways of, not holding people within four walls? Are there alternatives to such practices? But some groups are saying, well, really, we should, even as we advocate for alternatives, we should always bear in mind that the abolition of immigration detention is what we are aiming for. But some groups say, well, if you start with that, if you even raise that in the room, governments will just disengage. So should we even call for abolition or not? So that remains an outstanding debate among civil society groups. So that's it from me. It's still a very early stage of analysis, so I welcome any thoughts or criticisms. And also, James, I welcome you to join in the conversation as well. Thank you for the work that you've been doing on this topic.
So first of all, I should say thank you very much for the very interesting topic, and it's that really you have wonderful ideas, because the project is really interesting and somehow addresses many issues. But first, let me see if we have any questions from the audience. Anybody from the audience?
I have a question.
Yes. Dottore, professore, I don't know.
Doctor, not
okay. Yes, absolutely.
Yes. This is not a real question. I just wanted to say how much I appreciated your speech, and that I fully agree with your position, because you said that we have to avoid center of detention, and by doing that we can ensure the cooperation of migrants for investigation and for proceedings against the traffickers, against the people who smuggled or trafficked those migrants. So I think that this is very, very important for the positive outcomes or possible trials against those trafficking, because even if a possible criticism may be that among those people there are also the traffickers, so by allowing them to stay outside, we can facilitate their escape or their run away. But on the other hand, treating them with a more human way, we can ensure the cooperation of migrants doing both at the investigative and at the trial level. Because if we can engage them during the investigative level, but we don't ensure their cooperation even at the moment of the trials, then we cannot use the evidence that we gathered at the investigative moment during the proceedings. So I really think that this can be a very effective means of ensuring and engaging with the migrants and ensuring their cooperation, which is at this stage very, very, very important.
Yeah. No, that's a really good point, Dr. Giuseppe, because as the studies also show that the trust is so important, and when you're holding people in a incarcerated effectively within four walls, the level of trust is very low. But if you do case management approaches where you're responding to the specific needs and the feedback of people who are in communities, there's less pressure on them, and they're more willing and able to share, you know, what they're going through and the struggles that they're having. So then, you know, their participation in court proceedings hopefully will also strengthen. No? So yeah, thank you for your comments.
Thank you very much.
I just wanted to welcome also Professor, I don't know you, but James Lewis, for participation and for joining us and for being with Alice. Let's see, maybe we have some other questions from the audience, because I have many, but I shouldn't monopolize this platform. So any questions? Academic students, Jean Monnet platform. I will explain what I mean by Jean Monnet platform later on, but so any questions? No questions? One second, maybe I don't see on all pages. No,
good morning, I have a question.
Yes, Benedetta, yeah. Benedetta, yes. Absolutely, Benedetta is my student, a very bright student, so absolutely, Benedetta, the floor is yours.
So I have a question for each one of the three panelists that spoke so far. One for Professor Na, and I'd like to ask if you can clarify the point where you say that those practices can be co-opted by states, and also if by saying that you think that those alternatives to detention cannot be seen as durable solutions and practices to detention. So yeah, just if you can clarify the last point and the last thoughts of your presentation. And then I have another question for Professor Jones, and you have shown in your presentation that there are many categories that UNHCR has to describe the population of refugees. And I was thinking if the those categories that are considered vulnerable by the UNHCR do not risk to create some sort of hierarchy and further differentiate the group of refugees, for instance, those coming to Europe, and therefore also influence their access to services, facilities within the hosting society, and it somehow bias their integration process. And then I have one last question for Federica Bellassai. Who are the partners or institutions that the IRC could further improve its relationship with in order to facilitate the dialogue with migrants and better protect and assist them? Thank you very much.
Sure. Absolutely no problem. Yes, Federica, I was just worried if
yeah, I'm here.
Absolutely. So we go ahead with this question, absolutely, because we said we need to give the floor to our students. I'm very, very grateful. But if there are too many questions, maybe we can place them afterwards, because I believe that the other speakers would be delayed. Okay, but with this one, we are done.
So thank you so much, Benedetta, for your question. James, would you like to respond to her question?
Yes. So when we talk about the idea that alternatives to detention are being co-opted, this kind of really begins with the idea that because there is such a vague definition, or not a universally agreed definition of alternatives to detention, and then within that, when you have so many different policies which are classed as alternatives to detention, what the risk is there is that we may say, as advocates, we fully support these certain aspects of it. So, for example, a study by Amaral in 2013 interviewed 25 people who had experienced alternatives to detention in Europe. So, for example, those who were in Belgium, they were placed into community housing, and had a designated case manager. So what we would argue that yes, that is a good definition and good practice of alternatives to detention, whereas those people who were placed in the United Kingdom were placed on electronic tagging. So despite the fact that both of these are alternatives to detention, we as advocates are much more likely to be promoting the idea of access to community housing, access to case managers, and despite the fact that electronic tagging is technically an alternative to detention because you're not in detention, it is still an alternative form of detention because it limits your freedom of movement. So when we talk about, the idea of being co-opted, this is what we're talking about, how a state may promote itself as being more progressive in its detention management and policies, despite the fact it may actually be promoting alternative forms of detention. And another example, and I don't have a source for this, but having spoken to some people who kind of work on alternative detention, someone gave an example that I believe it was in Malaysia, whereby a state-funded detention centre they increased the services that they provide to children in detention, and they class this as an alternative detention. So despite the fact that it is promoting and actually continuing the detention of children, they phrased it as alternatives to detention. What was the second part of your question, sorry?
No, the second part was that in the last part of the presentation, Professor Na said that ATDs are a way to say that let's rethink the practices that are considered as alternative to detention. And so in this way, like, are they considered in the end as durable solutions, like those alternatives to detention that have high compliance rates and that are cost effective, like if they can be seen and intended as durable solutions?
Okay, yeah. I mean, personally, I believe that when the alternative detention that we see that have high compliance rates, the ones that are, as I think Alice mentioned, like human focused, ensuring that they have access to services, access to mental health services as well. These ones, and also being much more cost effective, these ones I believe are very, very durable. But then the risk obviously is if a state wanted to, they could, for example, a state could purposely delay the process of people who are in alternative detention, maybe to purposely increase the cost of these policies. Again, I haven't seen evidence of this happening, but if a state wanted to try and discredit alternative detention, that is a possible solution that they could go for. So I think, yes, to answer your question, I think they are very durable solutions. I mean, again, they're better for the actual person. You're gonna not have as many limitations on the person, and as well as being more cost effective. I think in the long run, if states were to go down the route of following these good practices, I think you would see very good solutions to this.
Yeah. I think just one last comment to add to what James has said. When we talk about the durability of the solution, a lot of the alternatives to detention, they are in pilot phases run by NGOs, So the case management is actually done by NGOs, and I think really and funded by philanthropic organizations. So really to make them in their more durable form, they need to either be funded by states or run by states. And therein lies the issue, whether migrants themselves would trust state authorities in the same way as they trust NGO organizations or not. And I think that needs to be considered.
Thank you very much.
Yeah, it was a question. Well, if it's okay, if you remember your questions, that we could do a little bit later. Federica, is that okay?
Yeah.
Okay, Martin, because otherwise, sometimes people, they have something else. So if we run 2 hours later, you understand, they might have to teach or something. Well, just 2 things that I don't forget for Alice. I just would like to address. finances. So how much does it cost? And especially this was one of my issues also about vulnerable groups. Yes, it's good to provide special assistance, but how much it would cost? What sort of finance? Poverty, alienation. So this is what then you said, this is a little bit like we in COVID situation, more restriction. So finally we are trying to do better, but finally we introduce more restrictions. And the last thing in the concept, in the context of EU, you know that we have return directive and we have this forced returns, like for instance towards Afghanistan, and now the issue is, how would you organize this? Well, Salvini, Minister Salvini at one time, he wanted to empty one camp and he just provided buses, but the migrants were not there anymore. So when the buses came, when the buses came, there was nobody to take on those buses because, well, they didn't want to be allocated and so on. So they disappeared. So this is it not true, Professor Ricci, that it was just like this, what I remember, but maybe not now. So how would you do it such a situation? Because we need to go to our following speaker. Thank you very much, Dr. Romeo, that I made a mistake. I do apologize. So this was a conference in Messina that provided me some excellent ideas for speakers. So Professor Dr. Giuseppe Romeo from Messina is going to talk about transnational criminal organizations and migrants, torturers and victims of illegal trafficking of persons. So vulnerability in form of victims and oppressors. So Dr. Romeo, sorry, like Romeo and Juliet. Okay, so I just now remember now forever.
Exactly. Okay. Thank you very much, Professor Gromek, for inviting me today and giving me the opportunity to add a piece to this very interesting debate. I remember very happily the Congress of Messina in 2019, where we first met. So I'm very glad to be here. Well, my discussion, my speech will focus on the main subjects of the main actors of international trafficking of persons. In other words, the traffickers, the criminal organizations on one hand, and migrants. So in order to better understand the phenomenon and to reflect on the most effective tools for tackling this transnational crime on one hand, and for protecting the victims on the other hand. As we know, the world population is growing every year, and so is the volume of trade. The increase of such commercial exchanges was also driven by the increase in the last 25 years of migratory flows. In this context, criminal organizations have been able to create a real illicit market capable of recruiting, subjugating, transporting, and eventually exploiting migrants in a plurality of illegal activities. This is the so-called international trafficking of persons. Italy, in particular, placing itself at the crossroads of numerous of migratory routes, has found itself particularly exposed to this phenomenon. But what are the main causes of this phenomenon? We can remember three of them. The three main causes are the growing gap between industrialized and developing countries, the mood of growing political and religious instability in certain areas of the globe, and to climate change. We know that because of climate change, a lot of people are escaping from their countries of origin. So the need to combat this new transnational crime raises multiple questions on the two subjective poles of this crime, which are the criminal organization, in order to understand the transnational nature of them, of those organizations, and of the migrant, who has to be seen as a real and effective victim of the international trafficking of persons, who deserves adequate protection in the difficult and subtle distinction between trafficking in person and smuggling of human beings, and smuggling of migrants and trafficking in human beings. With the reference to the first profile, the profile of criminal organization, the phenomenon, first of all, of being for acquiring a transnational nature has a nature of organized crime, which requires diversification of roles and a structure. Moreover, organized crime related to smuggling and trafficking has undergone a progressive internationalization that has favored its expansion beyond national borders. The causes can be found, among others, in the intrinsic nature of the goods exchanged. The migrant, of course, come from a different country from that of destination, and to globalization of economy. Organized crime, therefore, taking advantage of the existence of larger holes in international communications and exchanges, has been able to cross national borders much more easily. Therefore, it emerged the real transnational nature of organized crime in this context. And with this expression, we allude to the cooperation that different criminal groups have established among themselves to manage more effectively this illicit market. Due to the strictly transnational nature of this crime, the presence of roles which requires a much more independence than the past led to an increasing demand of outsourcing of certain illegal activities. And this is another main feature of these new groups. They are therefore distinguished by a much more fluidity and flexibility. Traditionally, in fact, organized crime groups were characterized by hierarchical and territorial organizations. In this context, on the other hand, the new groups, without completely depriving themselves of forms of vertical control, are characterized by a looser network organization. It follows a greater attention and focus on the activity rather than on the group, whose components become interchangeable, and the same groups, if neutralized, are quickly replaced by new ones. This is the first subjective pole of transnational trafficking in person, and the other subjective poles, which have to be analyzed as well from a criminological and legal point of view, is the migrant. In order to identify the most effective tools for protection of its fundamental rights, seriously damaged by criminal conducts of extremely offensiveness and cruelty. First of all, we have to make a change of perspective, because often the migrants are not seen as a victim to be protected, but rather as a foreigner to be expelled and to be rejected. So in order to avoid the risk of disinterest towards migrants and to creating a category of second-rank victim, we have to switch from a view of the migrant as a foreigner and illegal foreigner to be expelled to a victim, a real victim to be protected. That being said, the migrant is treated in a radically different way, depending on whether he is subject to one of the two offenses of trafficking in persons, of illegal trafficking in persons, which are the smuggling of migrants, as we said, and trafficking in human beings. Because the status of migrants identifies itself with that one of the victim of the crime to be protected only in case of trafficking, not in case of smuggling in human beings as well, where the migrant is seen as an illegal immigrant to be expelled. This is because in the case of trafficking, the migrant passively undergoes trafficking as he is believed to be recruited without his consent through force and violence, or in the presence of a consent extorted with a deceptive conduct. In the second case, instead, it is the migrant who requests the irregular transport, placing himself almost as a partner in crime of the trafficker, who merely satisfies a demand coming from the former. So we can see the difference from a definitional point of view between those two offenses. Smuggling of migrants punishes the illegal transportation of migrants from a country to another country with the consent of the migrant for the purpose of profit. trafficking in human beings, on the other hand, punishes the illegal transportation of migrants without their consent or with a flawed consent of migrants with the purpose of their exploitation at the end of the journey. Therefore, the interests protected in the two cases, in the two offenses, are different. The smuggling of migrants protects a collective interest. That is the interest to protect national borders and to manage migratory flows. On the other hand, trafficking in persons is intended to protect an individual interest. That is the interest of the migrant, which is seen, as we said, as the real victim, as stated by its systematic placement in the Italian criminal code among crimes against the individual. From this difference, we can notice the different role of the migrant. In case of smuggling, the migrant is a mere object of the conduct. He is neither co-perpetrator nor victim of the illicit conduct, and his irregular status is a mere precondition of the unlawfulness of the conduct of those who allows or facilitate their entry or stay. The role of victim is instead undisputed in cases of trafficking, since the migrant holds the position of the offended person. This is not a mere descriptive distinction, since the measures for protecting fundamental rights of migrants are only provided for in case of trafficking in persons. So the differences are very important from this point of view, from the point of view of emphasizing specific measures for protection of the migrant, which are provided for only in case of trafficking and not in case of smuggling of migrants. But this overview is the result of an abstract and legal analysis, since there is no general consensus among national and international doctrine with reference to the exclusion of the role of victim towards the smuggled migrants. Indeed, in practice, the difference between those two conducts are much more blurry than from a definitional point of view. Let's think of the cases where the migrant is subjected to a position of slavery by the trafficker because the trafficker wants to subjugate the migrant in order to ensure the payment of the cost of the transportation. Or, for example, the migrant cannot pay for its transportation, so he can be exploited at the end of the transportation. In this case, we notice a merge between the two conducts, because the trip begins with a demand coming from the migrant, as stated by the definition of smuggling, but it ends with the purpose of exploitation, which is a character, a feature, a specific feature of trafficking in human beings. So the difference from a factual and concrete point of view are not so specific as from an abstract point of view, and there is a close link between those two conducts. There is, moreover, evidence of the torture, violence, and abuse to which migrants are subjected during the journey, so that we can say that smuggled migrants have undergo a position of vulnerability very close to the one of trafficked migrants. In fact, the statement according to which the individual voluntarily undergoes migration at the cost of his own life, it's not true. Indeed, the migrant is forced to go abroad, to go in another country, because of extremely poor conditions, or extremely condition of poverty or serious danger for his own safety. Hence, as a forced migrant, he deserves protection as well as trafficked migrant. This notwithstanding, on an international level, the migrant is considered as a real victim only in case of smuggling. Let's think of the United Nations Convention Against Transnational Organized Crime, the Convention of Palermo, which establishes a means of protection of the migrants only in the trafficking protocol and not in the smuggling protocol as well. In the smuggling protocol, while providing that migrants shall not be prosecuted for the illegal journey does not recognize them the status of victim, consequently ruling out the related protection measures. Hence, we need to extend the status of victim to smuggling migrants as well, since there isn't any significant difference between the vulnerable condition of the smuggled migrants and the vulnerable condition of the trafficked migrant. The smuggled migrant, in fact, has no real acceptable alternatives rather than submitting himself to the abuses in question. Once established that we need to extend the status of victim to smuggled migrants and not only to trafficked migrants, we have to reflect on what are those protection tools. And we can link to what we said before with Ms. Na. Indeed, the fight against international trafficking of persons can be said truly effective without the provision of instruments for the protection of the victims. The willingness, in fact, the willingness of trafficked persons to cooperate with the authorities depends on the existence or not of protection measures, of legal and social assistance, on the risk of being prosecuted for the illegal journey or for related crime, or of being expelled, as well on the respect of their privacy. To that end, the identification of the effective or the potential victims is a crucial moment. And I need to focus on I want to, how can I say, stress out the expression of potential victims, which are people, migrants, who are not, but maybe in the future be exploited. So the identification of both of those figures is very, very important. Indeed, a correct approach towards them can avoid the risks of negative outcomes of criminal proceedings against trafficking due to the limited availability of evidence, because of the reason we talked about before during my intervention to Ms. Na's speech. The trafficking protocols, in fact, provides for specific form of assistance of a procedural and social nature. Among the former, we can mention the need to guarantee confidentiality in the identity of the victims, provision of legal assistance so that the victim can express his views and concerns during the criminal trials against the traffickers, and compensatory measures for the suffered pain. Among the forms of social assistance, we can mention adequate accommodation opportunities, medical, psychological, and material assistance, employment opportunities, education, and mental assistance. Only through these protection tools we can ensure the cooperation of the migrant for not only for protecting their fundamental rights, but to ensure their cooperation even in order to obtain the conviction of traffickers during criminal proceedings. In the context of European Union, with regard to this context, the main act is EU Directive number 36 of 2011. This directive, after establishing specific criminalization duties for member states, provides for numerous of protection measures for migrants who are victims of trafficking. But these are mainly overlapped to those provisions established in the trafficking protocol of United Nations Convention against International Criminal Organization. But there are some news. For example, the need to adopt preventive measures of secondary victimizations of migrants in order to avoid unnecessary repetition of hearings during investigation and criminal proceedings, to avoid eye contact with the defendant, which is normally the trafficker, avoid public hearings or irrelevant questions about private life. At the national level, the main legal act is Legislative Decree number 24 of 2014, which implements the EU Directive number 36 of 2011. For this reason, its provisions are mainly overlapped to that in the EU Directive that we just mentioned, even if it has some omissions, relevant omissions, such as the provisions for preventive measures of secondary victimization, which do not find place in this legislative decree. In conclusion, an holistic approach to illegal migration, which aims to tackle the illicit trafficking of migrants, need to take into consideration a legal and criminological analysis of its two main actors, transnational criminal organization and the victims. And by victims, we mean both smuggled and trafficked migrants. The study of the former, so of the criminal organization, allows us to understand how the most effective weapons against trafficking do not have to address neither the individual nor the group, but rather the illicit profits, because of the economic nature of this crime. So we need a suitable mechanism to identify, freeze, and seize the illicit capital managed and accumulated by those groups. And for example, at the EU level, we have the EU Directive number 42 of 2014, which provided for specific seizure measures against organized crime, for example. On the other hand, we have to reduce pull factors of irregular migration by implementing measures, economic and geopolitical measures, in order to reduce the demand of irregular migration. The study of the migrant allows them to identify the most effective ways of approaching them in order to ensure their investigative procedural cooperation, as well as identifying the most appropriate tools for assistance, bearing in mind the serious violation of fundamental rights they suffered during their journey. Thank you.
Thank you ever so much. Thank you for this very interesting talk. I have some comments, but first the floor. And also I would like to ask if Federica is here, because maybe we can answer the Benedetta question, because otherwise we will never be able to answer the questions which were interesting.
I'm here.
Yeah. Any questions for Dr. Giuseppe? Giuseppe, how Alice is calling Dr. Giuseppe. Dr. Giuseppe, any questions? Benedetta has a question for Dr. Giuseppe? No. Dr. Any questions? So your argument is, I always comment something. So your argument is extended vulnerability for smugglers. As we know, the definition of smuggling people, they have a part of their own responsibility what happens to them. So again, not to be tacky, but I think that the question is how your ex-minister Salvini, nothing wrong, would have taken that. Already he got a headache with children as vulnerable groups that need to be protected. So if we extend, in addition, smuggling people into the definition of vulnerability, so we would need to provide them special protection. So I don't know how it would be accommodated. It could have been accommodated in the time of Salvini, but the time is changing. Another issue on this, it would be how first of all, what sort of data we have during the pandemic crisis on smuggling? Has it been a little bit lower than normal, or completely pandemic does not influence this at all?
Well, I believe that during the pandemic times period, the data are a bit lower than before, because of every kind of journey has been stopped. But I don't think that he completely stopped the phenomenon of irregular transportation of migrants. With reference to your first question, I think that the issue is the status of vulnerability of the migrant. This is not a matter of whether the demand of migration comes from the migrant or not, so, which is the difference between migration and trafficking. The matter is if the migrant deserves protection because he's in a vulnerable position. So even if it's a woman, even if it's a child, or a smuggled or trafficked migrant, in the cases they are in a vulnerable position, they require adequate means and adequate ways of protection of their fundamental rights. Of course, maybe if they do not have the right to remain, to stay in the state of destination, maybe they can be expelled, but not before recognizing them the obvious means of protection of their fundamental rights, because of the sorrow they underwent during their trip. So I think this is a matter of, and this is a thing that a fil rouge of all those interventions that we're going to have today. This is on the basis of whether there is a vulnerable position or not of the migrant.
Excellent. Well, but now I can, well, so we know that the definition, well, I did specify to all my speakers that starting point is the definition of vulnerability within the SIA system. Why? Because when we go a little bit wider, we can talk about disability, how it is construed within the EU law or within UN Convention on Disability. Now, the issue that the SIA system provides some elements into what does it mean position of vulnerability, but it's not completely, well, we can say it's not an exhaustive list, so we can say this, and this your idea, and we have those specifications: the elderly, women if they have specific, well, if they are pregnant, or the elderly, and so on. So here the question would be to discuss, is a smuggling person in the position of vulnerability? And this is your argument, that your argument is that yes, it is, but I think that it's very interesting for an article. So why do you think that the position, and this is what your talk was about, that why a smuggling person is in the position of vulnerability within the definition? Or we might say that it's not within the definition of EU law, but this is form of vulnerability that should be considered. So this is what I said to Professor Jones, that it's not really what is in the definition, but what it's not. So this is what is more important. Any questions for Dr. Romeo? If we don't, maybe we can consider the one question of Benedetta for Dottoressa Bellassai, because otherwise, so where is Benedetta? Ah, Benedetta is here. Okay.
Okay, so if I remember, the question was about our collaboration with other stakeholders to enhance the protection of people we assist. So we can say that the Italian Red Cross works on two levels of collaboration, because the first one, and I think the most, let me say, important for us, or at least impactful for our intervene, is for sure the network. Because each person we work for can receive support from different components of our international movement. I mean, if a person starts his journey from a little place from Africa, that person can meet one person from the Red Cross. So the protection approach starts from the first stage of the journey, the migration in this case, till the last place of arrival, in this sense, Italy. But in the sense of institutional collaboration, of course, we are working a lot also on the advocacy, but is not the classical advocacy when the people speak louder to speak about the rights of person, but through real action. For example, also the collaboration that we have with sometimes at local level with some non-detention in Italian is oh my God, places like centri di oh my God, the carceri. So I don't know in English because the difference is
alternative to detention, I think.
Yeah, alternative detention, yes. For example, to maintain the contacts of all the people in detention situation, or for example, also on the missing person, we have this collaboration also with the authorities for missing person in Italy. So the Italian Red Cross is like to focus the attention through institutional collaboration also to these important topics. Of course, in the tracing process, we do, for example, to restore or to trace some people who is missing, we collaborate with the Ministry of Interior just to understand if the person, for example, is still in the territory or not. So, of course, this is a kind of alternative way to do advocacy on these themes and on these topics. I also would like to add something related to the previous topics, that was the family reunification and alternative schemes to support the unity right of family members, because also in these topics the Italian Red Cross is present, because just some months ago we are starting a project to the alternative schemes in the family reunification, and this is in line with our view and our vision to family unity, that is not strictly linked with the family reunification concept at we can say at institutional level, but with a sense, a meaning of family reunification larger than the institutional point of view. So also in this, I would like just to add something. I don't know, Benedetta, if I gave an answer to your question, or if you want to know something else on our response on this.
Benedetta, we can't hear you.
Yeah.
Okay. We can't hear you. Okay, guys, Benedetta, if you could maybe send the questions maybe in chat, and we could maybe, because we can't hear you at the moment. Yeah. And
you can write.
I have to first, so we can maybe address this a little bit later on. The next would be Professor Martin Jones from the questions that remain. But first of all, I would like to thank very much Dottore Giuseppi. I really like this. Dottore Giuseppi, it's very interesting. It had a real argument, and I really need to think a little bit about this argument. Anybody has a question? Well, why don't you reflect on the question for Dr. Giuseppe, and I will go ahead with the conference because we are just a little bit late. So I said that the EU law cannot be seen in isolation from international law. It's absolutely impossible, and they are really connected. In the same way, I just want to say that the conference is very interdisciplinary. It's very interdisciplinary for the purpose that, again, we cannot see vulnerability only from the legal point of view or political point of view, but we need history, we need sociology, we need other disciplines to be able to understand what the content of vulnerability. So here in Pavia, we have a group, a very active group that works on migration, and we have researchers and professoressa, dottoressa Fusari?
Dottoressa, va benissimo anche solo il nome.
Valentina Fusari will give us a different account, a different view or insight into vulnerability, and her talk, and she is from Pavia, she's from our team in Pavia, and she will be talking about the portrait of vulnerability from hidden populations to positive discrimination. So thank you, the floor is yours.
Thank you, Professor Gromer, for your invitation. And yes, what I would like to do today is to share with you some of my reflections that come, let's say, from the fieldwork. I'm an anthropologist, and my research are focused mainly in the Horn of Africa and in Eritrea. So when I'm there and during my, let's say, my research, I am mostly in touch with people that in the eyes of Europeans can have a high probability to be a vulnerable group once they migrate, as Eritrea is one of the main refugee producer in the Horn of Africa or in the sub-Saharan African countries. So what I would like to do is to make a step back and try to understand if the definition used or commonly known about vulnerability is something that works also out of the European or the legal framework. And what I try to do is just to put them in a different context, because in my opinion, vulnerability and vulnerable group are context dependent. So we have a lot of definition that can help us in stipulated guidelines to treat and to grant protection to specific vulnerable population. But the concept of vulnerability and also the criteria to design vulnerable population, in my opinion, they are a little bit vague. So we have vulnerability that is a kind of abstract concept, a kind of fluid concept, but that has concrete effects on not only on the people that can be labeled as vulnerable, but also for the one that need to treat, or the one that need to be in touch with this group and to protect this group, but also for researchers. So I just start from the simple definition that the Oxford Dictionary provides for vulnerable people, that are those exposed to the possibility of being attacked or harmed, either physically or emotionally. So let's say that vulnerability has intrinsic factors related to individuals, but also external factors that are more linked to the community or the environment. So vulnerability is a multidimensional construct, and because of that, we can be exposed as human beings to different kind of risk. And these different kind of risks not only determine our level of vulnerability, but they determine our status. And the status is something that is usually socially constructed within a society. It's a category. So if this is a category, we should make an effort to think that also vulnerability, it is a socially constructed and content-dependent concept. And when I say content dependent, it doesn't mean only a physical or a cultural or a sociocultural or economic environment, but also, for example, a legal environment. In the case of the Charter of Justice of the European Union, we can consider this one as the environment, as the framework that is able to socialize people that are vulnerable and people are going to work with vulnerable group. So just I consider in my presentation vulnerability as a buzzword, as a notion that is able to account for a lot of situations that people are facing or that people had faced in their country of origin, if you're speaking about migrants. But at the same time, I would like to consider it also a positive situation in the sense that it creates the condition to move out of a marginal situation as well as disadvantaged situation. So my communication is threefold. First of all, I would like to stress the content-related nature of vulnerability. Then I would like to understand how it relates with different forms of powers and how a bottom-up agency can emerge, can engender from the situation, from a disadvantaged situation. And then I would like to outline some challenges that I've experienced during research with vulnerable groups. So the first point is that if we assume that vulnerability is a universal and constitutive condition of the human being, it means that at every time we are at risk of something. Nevertheless, we consider someone vulnerable only in a situational content-dependent situation. So at the, let's say, theoretical level is something that concerns the full population, is something that concerns every human being. But at the situational level, at the individual or group level, it's something that is characterized by particularity and uniqueness. So it means that there are some social devices and some social processes that are able to make people vulnerable and to lead these people to marginalization or exclusion or oppression. And the most of the time we are looking for one simple situation that can determine the status of the people. Instead, as the intersectionality says, there are an overlapping level that can determine a specific status. So usually I try to summarize this situation when I read the title of our seminar, I thought, okay, thinking about the Eritrean migrants. Are they vulnerable because they are migrant, or are they migrant because they are vulnerable in their own countries? And this changes perspective can change their status of vulnerable people under, let's say, a strong and strictly regime, or are they vulnerable because they face specific oppression during their travel from out of Eritrea to Europe, let's say, for example, in Libya. So on the basis of these questions, I think that the important criteria to define a vulnerable people is that is to something. So when as social scientist, I try to approach a vulnerable group, I should first of all define their vulnerability. So I should first of all define to what are they vulnerable, what determine their condition. And also I have to understand which network can ease or help them to cope with this situation, and also how their situation can change moving out of a context. So sometimes we are not solving vulnerability, working on vulnerability, but just changing the context. But changing the context doesn't change the mind of where these people has been socialized to specific, for example, bodies difference, as well as cultural or religious or gender differences. So the most of the time we are used to approach these people as passive groups. But going now to the second point, I've seen that the most of the time they are active group. Vulnerability is not per se a limiting condition. Sometimes it is the motivation. So as I'm vulnerable here, I decide to move without knowing if during my travel heading to Europe, maybe I can be even more exploited than what I am in my own country. Or maybe I have been marginalized because my sexual orientation, and it can I can be hosted in let's say a center where I experience the same offenses or the same oppression. So we have the same situation that can be approached by different actors in different ways, in different time and context. What I've seen during research with Eritreans is that the most of the time their situation as vulnerable people push them to mobilize material and immaterial resources to move out of their condition. So the risk is that if we not consider the positive side of the vulnerable group, or what vulnerability can create in this vulnerable group, the risk is that our approach is just a paternalistic approach in solving the problem or assuming to solve the problem of vulnerable people or group. How many times are we considered as perspective in the solution we put in place when we are going to solve their situation or to change their status? In another example, not in the Eritrean case, but in Jordan, for example, that in order to solve the problem of the Syrian women that reach Jordan, we create a kind of positive discrimination towards the refugees, but we decrease the services, above all in terms of education, in terms of health, in terms of water for local population. So what happened is that in order to solve the problem of a vulnerable group, we create another, let's say, self-perceived vulnerable group that start a kind of risk chain. So there are a lot of people that now is under attack, under verbal attack, under physical attack because they have been helped by international organizations, they have been helped by third-party actors, and so on. So the most of the time, the risk is that, above all outside Europe, that the intervention of European or non-local or not socialized groups can create a chain of risk instead of diminishing the vulnerability of specific groups. And the last point that I think it's a different compared to the legal system I heard until now, is that when we are working with vulnerable group in their place of origin, in their country of origin, the most of the time they are hard to reach, they are hidden population. So they are not so easy to find, they're not so easy to recruit. It's really hard to create a sample that can be representative by a statistical point of view. And it's really a risk to get in touch with this person for the researcher, but also for the people that on the one side, they will like or use or take the opportunity of the researcher to speak out about their vulnerabilities, but at the same time to speak out of their vulnerability, increase the degree of their vulnerability. And so we should put in place a long list of ethical, practical, and methodological resources in order to keep our key informant safe, to be sure that they are at least representing a group or the voices of the population, the small population they are of which they are part. And we should also consider the implication, because the researcher, after maybe 1, 2, 3, 4 months, the researcher, they can go away, but that people have to hide even more than what they haven't done before. And in an egoistic point of view, we have to say also that also the researcher, then they don't know how they can or when they can exploit the material they have collected during the fieldwork. Because if the first priority is to keep safe your informant, it means also that it's not so easy to publish what you have collected during the fieldwork. Above all, if you are speaking of a minority, or if you are speaking a vulnerable group that maybe, let's think about the Eritrean case, a political opposition group that is hidden, is not existent. Or at the same, another example for the Eritrean case are the homosexual people. Homosexuality is forbidden, and homosexual people are put in jail for at least 10 years in Eritrea. But at the same time, if you speak with Eritreans, they say in Eritrea, homosexuality doesn't exist. But if you look at the data concerning the cause of requesting protection in Europe, we've seen that a lot of Eritreans, they have used homosexuality as the motivation to ask for protection. So every time we have to cope with something that in the society doesn't exist. At the legal point of view, it's punished, and it's something that is recognized as a cause that can lead to protection. It's something that determines a vulnerable group. So as an anthropologist, what I hope for the further research is that we can really boost interdisciplinarity, because of the time, most of the time, the categories we use to design, to outline vulnerable people are not understood in the places of origin, and they can be only exploited in the, let's say, movement from one context to another context. And another point is that we can maybe try to discuss and to understand what is the meaning or the local terms used to describe and define vulnerable people. The same things happen with, for example, development. A lot of in Eritrean, we have 9 ethnic groups. 4 of them, they didn't have at that time a word to describe the word development, but international agency and donors were pushing for development. At this time, we are pushing for safeguard and treat as or at least change the status of vulnerable population. But who are these vulnerable population? Can they be self-defined? Are we considering self-defined categories as vulnerable, or to be vulnerable, these people have to fall into a predetermined category? So I've finished, and it's only, I know, a kind of sharing my reflection, because a lot of things and other case studies and example will be described this morning, but also in the afternoon. So thank you.
So thank you very much, Dottoressa Valentina. This was very interesting. Well, my idea is really very interesting and a little bit it puts us in a different context. So for instance, what I learn and what I like it really, that it's content dependent, completely agree on this. Multi-dimensional construct, absolutely. Intersectionality, that I would like you to explore on this. But what I suggest, if you are not extremely in a hurry, maybe we can get Dottoressa Dal Zotto, because she has some problems with child care and so on, and then we can stay for the discussion. Just the only one thing, that this is the same that I would have this reflection to Dr. Giuseppe. I like this. So the issue is that the law needs to be precise, because the law, as I'm teaching my students what the law is. So the law triggers certain responsibility. So saying that, yes, we have different, we have to construe vulnerability wider and so on. Yes, but we need also to have some brackets that would tell you that if you don't observe, there is a certain responsibility that would be triggered. So saying position of vulnerability without specific, but what, well, so this is the argument that we can explore more and more and more. But what I'm saying, that saying only that, yes, smuggling people are vulnerable, we have to determine certain parameters in law. But anyway, questions later on. Dottoressa Dal Zotto was extremely active in migrating group, and she is she has done many projects as well on this. So I'm sure, and finally, I'm sure that she particularly liked this topic when I told her. So the floor is yours, Dottoressa Dal Zotto.
Thank you to Professoressa Gromek for organizing this really interesting event. And I apologize for coming so late, but I had baby management problem this morning for the new red zone, so I apologize. My intervention will focus on the recent changes in the Italian reception systems, on its historical limits and how they meet condition of vulnerability. The first forward is in which way we assume the concept of vulnerability. We can intend vulnerability as a universal condition. So we consider that there are no invulnerable subjects. But we can assume vulnerability also as a particularistic condition, so a prerogative of a certain group, for example, for their age. This particularistic assumption can lead to stereotyping and the victimization of this group. But at the same time, particular and contextual dimension of vulnerability allow to capture the diversified experience of the subject and their location at the crossroads of multiple potentially vulnerable and discriminating factors, just to follow the concept of intersectionality introduced by Valentina Fusari before. So, vulnerability is a human condition that is both universal and particular, original and derivative. It depends from economic, political, cultural, and legal assets in which subjects are inserted. My second forward, it's related to the fact that current restrictive policies and norms regarding international migration produce vulnerabilities that are independent of war, persecution, and discrimination. At the same time, this vulnerability risks to restrict the right of asylum seekers. It seems in some cases that we have to be vulnerable to receive protection. It's not just an issue of protection, it's also an issue of reception. Under the European law, we find the concept of vulnerability both in the directive related to the status of asylum seeker, the qualification directive, and in the directive related to the reception of applicants for international protection. Let's see how it's work in Italy and the Italian reception system. In Italy, the directive on reception has been adopted through the decree 142 in 2015. And this decree pay particular attention to subjects with special needs in its article 17. The so-called vulnerable people, whose number is extended compared to the past, for which specific measures are introduced in the reception and in assistance procedure. Those special reception services are activated within the governmental centers, also ensured in collaboration with the local health authority competent for the local area, which must guarantee particular assistance measures and adequate psychological support. Among all the categories of vulnerability, particular provisions are reserved for the reception of unaccompanied foreign minors. The Article 17 of this decree provides that reception is provided taking into account the special need of asylum seekers, in particular those of vulnerable persons such as children, unaccompanied children, disabled persons, elderly people, pregnant women, single parents with minor children, persons who have been subjected to torture, rape, or other forms of psychological, physical, or sexual violence, victims of trafficking and genital mutilation, as well as persons affected by serious illness or mental disorders. The decree, in the attempt to give an organic structure to the Italian reception system, which from its birth at the end of the 90s is characterized by fragmentation and by an emergency approach, distinguishes between a first reception based on governmental centers, which also include those of extraordinary reception, and the second level of reception, the protection system for asylum seekers and holders of international protection, the so-called SPRAR. The SPRAR in the last 2 years has undergone profound transformations. The decree law for October 2018, number 113, renamed the SPRAR in SIPROIMI, Protection System for Holder of International Protection and for Unaccompanied Foreign Minors, and reserve access to holder of international protection, so asylum seekers are not allowed to enter in this system, unaccompanied minors, person in possession of residence permits for special cases, medical treatment, disaster in the country of origins, and act of particular civil value. Special cases are those related to a particular situation of vulnerability, like victim of trafficking, domestic violence, severe labor exploitation. I would like to highlight that this law concerned the stay permit for humanitarian reason. This permit that was residual with respect to form of international protection in the past made it possible to take into account situation of vulnerability that did not have to do with the country of origin, but which were the result of the migratory path. Anyway, this law has repealed the provision that envisaged the activation of special reception services in the sparsi proimi facilities for vulnerable people. Currently, in case vulnerable people reach to access the SIPROIMI system after the grant of a title of protection that allowed the access, they could enjoy some additional services allowed by the decree 18 November 19 for disabled persons and persons affected by serious illness or mental disorders. The law clarified the need to set up specific spaces within governmental first reception center where services related to the information, legal counseling, psychological support, and receiving visitors are ensured. Where possible, adult vulnerable people are placed together with other adult family members already present in reception center. The manager of reception center shall inform the prefecture on the presence of vulnerable applicants for the possible activation of procedural safeguards allowing the presence of supporting personnel during the personal interview. Again, another change came in the last year with the law 173 of 18 December 2020 that renames SIPROIMI into SAI, the Reception and Integration System. The new law provides for the reception of applicants for international protection, as well as holders of protection, unaccompanied foreign minors, as well as foreign entrusted to the social services upon reaching the age of majority. Furthermore, holders of stay permits for special protection, for special cases, victim of disaster, migrants to whom recognized particular civil value, holder of residence permits for medical treatment. Within the system, two levels of reception service are provided. Applicants for international protection access the first level and access all the other categories listed above at the second level, aimed at integration. In the last, in 2019, that is the last year for which we have complete data, so we are considering not the new SAI, but the SIPROIMI. In front of 844 projects, 47 were for people with mental and physical disabilities. 166 projects were for unaccompanied minors, and 631 were for the so-called ordinary categories. From the analysis of the annual report related to the activities carried out in 2019 by the projects that welcome both adults and minors, a significant presence of beneficiaries in condition of vulnerability emerged. The most significant data refer to victims of torture and violence, the 8.4% of the total, a slight increase compared to that recorded in the previous year, followed by the victim of trafficking, 4.9, and the beneficiaries with mental health problem, 3.7%. If attention is focused exclusively on the last useful year, a clear gender differentiation clearly emerges. Women are for the most part victims of trafficking and torture and violence. The experience gained over the years has led to note that conditions of vulnerability are quite widespread among the population of forced migrants. This has led to the need to respond to these needs with a reception network able to guarantee an effective and widespread take-up of the various vulnerabilities through the territory, through an homogeneous increase in a reception standard and an increasingly integrated approach in the local welfare system. Taking charge of people with vulnerabilities or with special needs involve greater complexity in terms of reading needs, emergence of discomfort, building a relationship of trust, and requires strengthening networking with local, public, and private individuals, and with external professionalism and expertise able to support treatment, rehabilitation, and reintegration paths. Many steps have been taken by reception system in this direction, but critical aspects still remain at the moment. And I move to my conclusion, starting from this critical aspect still remaining. So due to the historical underdimensioning of the reception, the scarcity of resources dedicated to it, and the emergency approach that characterizes it, it happened the provision of the law for receiving vulnerable are disregarded, or that reception itself give rise to or exacerbate situation of vulnerability. The reception decree 142 in 2015 provide that asylum applicants undergo a health check since they entered the first reception center and in the temporary reception structure to assess their health condition, especially reception need. Actually, there are no legal provisions on how, when, and by whom this assessment should be carried out. The decree provides, in theory, that special services addressed to vulnerable people with special needs shall be ensured in first reception center. However, the reduction of funding and services provided in first reception center under the 20 November 18 tender specification scheme, the so-called capitolato of the Ministry of Interior, and the exclusion of psychology services from eligible cost will render the effective identification and protection of this category of people even more precarious. Again, in first reception center, no specific or standardized mechanisms are put in place to prevent the gender-based violence. Concerning the historical underdimensioning because the lack of places available in Siproimi in the former SPRAR, it's not always possible to transfer their families in vulnerability condition, unaccompanied minors, or unaccompanied minors asylum seekers who have become adult. At the end of 2019, the total number of unaccompanied children accommodated in Italy was 6,054. Of those, the 94.5% were accommodated in reception facilities, while 5.4% were accommodated in private housing. As of January 2020, 2,000 places were financed for unaccompanied children in 155 Sprarsi Proimi project. The number of places dedicated to unaccompanied children still fall short of current need. So 6,000 unaccompanied children present now in the reception system. For the bad condition in in some cases, in first reception of unaccompanied minors lead to 5,000 unaccompanied children absconding the accommodation. For unaccompanied minors were implemented, stay in first reception center cannot exceed 30 days and must last for the strictly necessary time for identification, which must be completed within 10 days. These serve to identify and assess the age of the child and to receive any information on the right recognized to the child and on the modalities of exercise of such right, including the right to apply for international protection. Throughout the time in which the child is accommodated in the first reception center, one or more meetings with an age development psychologist are provided, where necessary, in presence of cultural mediator, in order to understand the personal condition of the child, the reason and the circumstances of departure from his or her home country, and his or her travel, as well as his or her future expectations. The permanence of minor in first reception center is extended well beyond the deadline of 30 days and continue in most cases up to the actual completion of age, involving the lack of access to second reception project. Lack of sufficient number of centers for unaccompanied children in the border area, resulting in a lack of adequate response to the needs of unaccompanied children in transit at the northern border. Unaccompanied children cannot be held or detained in governmental reception center for adult NCPR. However, through 2017 and 18, both due to the problems related to age assessment and to the unavailability of places in dedicated shelter, there have been reported cases of children accommodating in adult reception center. All these, and concluding, all these examples confirm that if we consider vulnerability as something situational, we should remember that sometimes vulnerability arises not related to the starting condition of migrants, but to the travel. Humanitarian stay permit took this into account, and NGOs denounced that in the last 2 years, due to the withdrawal of the humanitarians from the SPRAR, the inclusion paths of many vulnerable people who had received this permit were interrupted. We can say the same for the time after the arrival in Italy. The waiting, the uncertainty in reception facility can lead in some cases to a psychopathological risk. So again, vulnerability can arise. Adequate resources are needed to avoid this phenomena. A reception system for asylum seekers and holders of protection, structured and appropriate to the current dimension of the phenomenon of forced migration, could help to offer adequate hospitality to those arriving in vulnerable condition and avoid the emergence of new situations. Thank you.
Thank you very much. Thank you. It was very, very, very interesting. And finally, Emanuela said that she's not a lawyer, but she addressed everything like a lawyer, because, well, so this is what the lawyers also do. Thank you. There are many, many issues that I want to thank you for. First of all, you provided the definition, because I missed, well, at the beginning I was so stressed, and I thought that I can't be late with different participants, so I didn't provide the definition, which should have been a starting point for the discussion later on. So what do we consider and how we can enlarge, or what we don't consider, and so on. And then you concentrated on Italian law, especially on those problems with, okay, we have a definition, but for instance, assessment of vulnerability, we don't know, you said, when, under which conditions, who should provide them. So all this really interesting, the problems that, for instance, they might not, disability might not have arisen from the beginning, but might be during the journey, and also so many issues. I open floor for discussion, for both. Where is Valentina? Valentina is here. I hope Valentina didn't go.
Yes, I'm here.
Right. And I also would like to know Alice. Alice is not here because we had some questions to Professor Jones, but he had written something, and I don't know if he's going to be back. He's not back, and Alice is not back. Okay, so just for our two speakers, Valentina and Emanuela. So any questions? Hello, who we have here? Maybe I don't see the hands. If you see, just let me know. I thought that it was a very interesting construction and added value to our interdisciplinary perspective. I hope that you see this from your perspective, that the legal framework is important in your context of your research, so your research is important in our context. So any questions? Where is Benedetta? Benedetta likes to ask questions. Benedetta, no. So any questions? So as I said, I have these questions, as I did say. For instance, you said that vulnerability is not, we don't know how it should be tested, under which conditions, who is doing this. So could you expand a little bit on this? This is a very important issue. And for Valentina, I have another question, which would be, Valentina mentioned at one point that vulnerability is a push factor. Is a push factor. Well, she didn't use this as a push factor, but this is what you said, that people move because of the vulnerability. So if you both could expand on this. Who is starting? So let's start with Valentina because she was before. So
okay, yes. What I've tried to say that vulnerability usually is the push factor, not only because people move because they feel vulnerable where they are and in the relation, in the context they fall, but also is a motivation in the sense that push people to find a solution to move out of the vulnerable situation, above all when it depends from environment, from physical environment. It's really harder when it depends on the community or the social environment, because it's not just you move from, for example, the seaside to the coastal area up to the highland because of malaria or because of other environmental or climate problems. The point is harder when you are stuck in a society that don't recognize or oppress you because it is, and you have been socialized to oppress maybe someone that is in your condition. In that case, it's harder to find a solution, but it's a motivation to find a solution. As much as you feel vulnerable, this suggests to capitalize on your material and immaterial resources. In the kind of migration, it's quite clear. Usually it's not, at least in Eritrea, an individual choice. It's a family choice or a community choice. Everybody is contributing, for example, collecting money or granting contacts to move out of the country, to move out of a condition. But imagine that you are homosexual there. I just use this example because it's clearly here when we arrive, and there is an increase in the request of human protection because of this cause. In that case, you can't capitalize on your network, because your network is the one that oppresses you. So what can you do? You can put in place other kind of agency. For example, you got married, you have your own family, you try to hide your condition, and then you move out of the country as a migrant, as an economic migrant. And once out of the country, you try to solve also that aspect of your vulnerability. So in this sense, is a positive in the sense that push and don't put the people in a position of just being passive, just waiting for someone that is going to solve your situation. And the next step is that when you find someone that is able to solve your situation, the risk is that they create a new kind of dependence, because of a paternalistic approach, because of I try to grant what you need now. I'm not giving you improving your skills or improving your human capital in order to upgrade in your life or in upgrade your condition or your family condition. Just I create a dependence to my, and this is a way to go. I think it's also a means of governability. In this case, the risk is that we use weaknesses in order to govern, in order to manage with a group that is a potential risk of upset or a potential risk of, I don't say revolution, but at least a tension, social tension. So I don't know if I...
Yes, no, you did. And what I'm saying that, well, yes, we could, then you raised many questions, for instance, what is not in the definition. So, and here again, I would relate to the discussion of Dr. Romeo, when he talks about the definition, but what we say. So we specified some grants, and the rest, it is just position of vulnerability, but it needs to be defined in some way. We can, because those people, they don't get protection. And this is exactly what Dottoressa Dal Zotto also mentioned, that yes, we have law which says you have more responsibility for those who are in position of vulnerability, but then how do we execute? So what is this follow-up? Because this follow-up might create a new vulnerability. And this is Dottoressa Dal Zotto. The questions did I already say? Yeah, I did, yeah. You need microphone.
Thank you for your question. As I said, many steps toward a better reception system have been done in the last 10 years after the emerging of forced migration phenomena in Italy in 2011. At the same time, especially in first reception center, the identification of a vulnerability is still difficult. I would stress the necessity of adequate resources to professional working in this kind of facilities, in order to can count on people prepared and trained to recognize form of vulnerability, situation of vulnerability, and resources to offer them more training opportunity related to this phenomenon. So the follow up can be this from my point of view, especially concerning first reception center, which are those more exposed to emergency situation. The problem, in my opinion, is not related to what became in the last year a well-organized system, like SPRAR, CIPROIMI on the now side, but first reception center and center of extraordinary reception.
Excellent. Well, I would have many questions, but so exactly what's the follow-up? So you said that there are many issues that should be considered, and at 3:50 we will have a guest from SPRAR that is going to talk about vulnerability. So if you could you know, connect, it would be really good. So the problem with vulnerability detection, how it is assessed, and finally the follow-up. Any other question on this issue? We don't have, but I will send him. Did Professor Jones said that he's going to come back in the afternoon, because we would like to have this. He had many questions, but I couldn't really, I just wanted to accommodate everybody, because I don't know, people, they have different obligations or something. So I thought that we could have, did he say that he will be back? Well, I would just, if he would be back, we would just address those issues. And then the idea of the definition that everybody said something about, but in the end we didn't somehow conclude on this, that there are many vulnerabilities with which the definition does not cover, and because the definition doesn't cover, it might be difficult for those having this kind of vulnerability to have special assistance or special follow-up or any kind of attention that this kind of vulnerability would require. For instance, Professor Jones, he mentioned this at international level, but this is the same in the CIAS system. As I said, that this is the basis of our consideration. For instance, the issue of homosexuality. Well, and then coming back, I'm just only to the definition, to how Dr. Giuseppe construed the position of vulnerability. We would say that yes, homosexuality is not included, but they would, however, come under the definition of position of vulnerability. Yes, but they might not receive the same attention, protection, and follow-up that they deserve. The same I could say about, for instance, Yazidis girls, if they were not raped or tortured. So they would be just, they would be migrant women. Well, and then you say that they still come under the position of vulnerability because well, but the definition should in somehow give them a little bit more power in some, because if they would be, they would be more. What Dr. Giuseppe wants to say?
I would like to say something about this. I think that migrants should be considered. I think that every treatment should be individualized. And what I mean by this, I mean that migrants have to be considered vulnerable per se, because they are migrants, because they undergo a journey at the risk of their own life. So the reason should be very, very, very strong if they drive them to such a dangerous journey. But on the other hand, they need to obtain an individualized treatment as well, because they are maybe homosexual, or because they are children. So they need to get specific specific assessment measures, because they are migrants. So in order to ensure their cooperation for procedural reason and so on. But on the other hand, they need specific and individualized measures, protection measures, because of their specific needs, because of their specific vulnerability positions that needs to be different from one person to another one.
However, Dr. Giuseppe, your idea is extremely costly. Well, it's just. I think that in reality, we simply cannot afford this. And it came out in the discourse of Dottoressa Dalzotto. And finally, why we don't have it. First of all, we don't have it because we cannot afford. Also, well, there would be some political reasons and there would be some others. And that's why the categories of vulnerability are reduced. Because this follow-up and this particular treatment for each of them, don't you think that there is something right with what I'm saying?
Yes, I agree absolutely with you, but we have two different points of view. The point of view of who deserves or not a specific,
yes, of course.
And the point of view of the effective, how can I say, implementation of those of these assistance. Of course, these are two completely different points of view, and I fully understand that yours. That it is really there are a lot of costs, but maybe as Ms. Na said before, by implementing maybe alternative measures to detention, we can maybe spend less than what we are spending now with the detention centers, which are much more costful. And maybe what was earned in this way can be spent by ensuring a specific means of assistance to those people, because at the end we can see how useless it is to provide for maybe a criminalization of those activities of trafficking and smuggling and so on, if at the end we cannot convict the perpetrators of those crimes. So in this way, by treating in a certain way the migrants, we ensure their cooperation, and at the end we ensure the conviction of those traffickers. Maybe this allows us to seize assets that traffickers possess, and maybe devolve those assets which have been seized through the cooperation of the migrants, and devolve them to the state in order to repay all those costs.
That's very right. Anybody wants to add? Dottoressa Dalzotto, Fusari?
Yes, shall I add just a consideration on Emanuela's, let's say, hope for the future in order to train people that is able to work in this reception, and they should be professional figure, professional profiles. And I think that sometimes we are not so keen in considering that vulnerability arises in reception centers.
Yes, this is, she said, in travel, in journey, but of course disability can.
Yes, and that's why we need really keen person, trained person, and not people that is just trying to do their best, but they are not the skills and the instrument in order to avoiding the engendering of new or different form of vulnerabilities that are also so distant from what a person can or perceive or imagine to reach in this center. And instead, concerning the proposal, let's say, or the idea of Dr. Romeo, yes, I don't know, but when we say we should do this or we should do this, what do you know about what is a smuggler or a trafficker in the eyes of the migrants? For example, the smugglers are the saviors. They are the heroes for a lot of people. So I think unless we do not consider who these figures, who these profiles are in the eyes of the migrants in this case, or in the eyes of other vulnerable peoples, it's hard to provide an approach that is able to benefit both the one that are in charge of, let's say, the hosting or the treatment of this population, and to consider, I mean, if I've been smuggled, I don't want to be considered as a vulnerable people, because there is my agency. I'm the one that is going to look for the smuggler. I'm the one that is going to collect money to pay for the smuggler. And I'm not going to tell who the smuggler is, because this can stop the opportunities for my brothers, for my sisters, and so on. Another discourse, in my opinion, should be done for the trafficker. But it's... I'm an anthropologist, and I know the legal categories and so on are important, but we are considered these categories as are not social creation. They are a lot ethnocentric, Eurocentric. I'm not so sure that can be easily accepted by a different perspective, and I'm not so sure that can be so taken for granted. What I've seen has been done is they are exploited. I have all my interest in being considering a vulnerable person. Although if I'm not a vulnerable person, but this can affect also the position, the status of other vulnerable persons. So in terms of how we can invest or spend the resources, I think we should go back to what Emanuela says, who is vulnerable and why?
But this is what you said in your discourse, multidimensional construct. So I put it this because I did like it. Just coming to Emanuela, well, finally, she evidenced the failure in monitoring and supervision, because her training relates to monitoring and supervision. So we have some rules, but we are unable to enforce them, for a variety of reasons. And this is Dr. Esa Balasai said, for instance, in COVID situation, in quarantine, where you need to separate. One is infected, another is not. But how do we follow this up? And you say, okay, we need preparation, but we are unable to prepare very often. And just like COVID situation shows you that we are unable, because it just happened, and we need to deal with this. We can continue, guys, this discussion, because it just leaves us only half an hour break. I hope that you would be able to come for a little bit, at least this afternoon, if you can manage. So we will start at 2. We will start at we will be looking at still in interdisciplinary perspective. There would be another element that I introduced, which is our Jean Monnet platform, which finally is about people who are doing different research, but we can still, in the area of migration, but we can still collaborate, and how. And also I will put specific attention on certain forms of disability. I just wanted to prepare the paper for this conference because there are very few that want to consider the elderly in migration. And I think that the very important point, because many years ago I was teaching labor law in the UK, and a very important point would be an access to benefits for the elderly migrants, those who are, for instance, that they are not yet registered. Well, they are registered, but they don't have any status, and so on. So how they survive, and what and who should do something for them. Anyway, this is a question for discussion. We will start at 2 p.m. Okay? Thank you very much. I think that it was very vibrant and interesting discussion, and we had lovely papers. And yes, and we will start at 2 p.m. Okay? So thank you ever so much, and see you in half an hour. Thank you.
See you later.
See you. Thank you. I just don't know how I cannot postpone this. I have to just leave this. I would prefer to postpone this, but anyway. So anyway, see you at 2. I hope that I will find a way.